Morning, Your Honor.
Good morning, Mr. Fedor. What case are you here on?
Demarion Cunningham with Mr. Clemens.
Okay, so that went to Judge Jefferson.
Oh, okay. Sorry, which one?
Judge Jefferson.
Oh, okay. All right. Thank you, Judge.
Good morning, Your Honor.
Good morning, Mr. Taylor.
How you doing? I have Patterson.
I see you.
All right.
Mr. Dozy.
Good morning, Judge. I have Mr. Javon Sparks, who's in custody.
All right. And Mr. Dottie. Dottie was here. Mr. Elsie, what are you here on?
Good morning, Judge. Here on Jalen Brazer, which except for this morning at the last minute yesterday for the motion to withdraw.
Okay.
Calling case number 2305-739001. People of the state of Michigan versus Jalen Brazier. Defendants charged in count 1, homicide, murder, second degree. Count 2, tampering with evidence, criminal case punishment by 10 years.
Appearances for the record, please.
Good morning, Your Honor. Ryan Elsey for the people. My P number is 81329.
Doty on behalf of Jalen Brazer, P75614.
All right. What's going on, Mr. Dottie?
Well, I sent in a motion to withdraw as an attorney. When I first began this case, when I spoke to the parents, I told them that the only way that they can retain an attorney, in my case, me, is that they could afford to retain an attorney and a second attorney to assist with the case because of the volume of the discovery, over 500 megabytes of discovery, which is basically an entire laptop computer filled with discovery. They told me that they were working on it. When I first was made aware of the arraignment date, it was supposed to be June 29th. Then I found out it got moved to June 13th on the afternoon of the 13th. So I didn't really have any time to get back with the clients and say, do you have the money or not? I've got to arraign him today. So I took care of the arraignment. The court then made me the attorney of record because I took care of the arraignment. If I didn't take care of the arraignment, he would have had no attorney to arraign this. The client still said they could afford a team of attorneys or more than one attorney because of the discovery. And then their financing fell through. In the best interest of my client, he needs to have me withdraw, select a court-appointed counsel that has the resources of more than one attorney. I have identified a group that can do this, and they've agreed to do this. And when they called the court, or they called the prosecutor's office or whoever they spoke to, they did require me to withdraw. It would probably have to go through the court-appointed list. before they could even get that. The group's name is called Neighborhood Defense Services. And I've already spoke to Jonathan Cohen, who's one of the attorneys in that group, and they're willing and able to take the case. They have the resources, they have multiple attorneys, and they would bring me on as second or third chair to assist in the case based on what I've known so far, because I've actually defended Jalen Brazer in his case in Macomb County. So in the interest of getting him the best possible defense, I can't do this alone. And they can't afford for me to bring in a couple other attorney friends of mine. I did ask other attorneys in Macomb County that I know that I thought would be willing to help. But when they saw the volume of the discovery, they all declined for the fact that there's little to no money involved for their assistance in this case. So in order for him to get the best possible defense, and for me not to miss something because I'm rushing through 500 megabytes of discovery and possibly make a mistake and thus affecting potentially an outcome of any trial for him, the best thing for him to do is to have me withdraw, have him get a court-appointed attorney, or have Neighborhood Defense Services take the case, and then I can join either one of those groups to assist. And that's what I propose, because anything else is going to be a disaster. I spent 10 hours going through the discovery, and I haven't even dented the 500 megabytes yet. So it would be unfair to him to put him in that spot.
When is this matter scheduled for exam?
27th, I believe.
It's the 25th, Your Honor.
25th.
Next Tuesday?
Yes, Your Honor.
So, Mr. Gotti, the only way I would be inclined to let you off this matter is if NDS or whomever takes over is ready to go on the 25th.
I guess I couldn't speak for them. I don't even know who that person would be at this point.
Your Honor, may I interject? This is Attorney Pilkowitz with NDS.
Go ahead.
I'm sorry, I've just been listening in on kind of what's been going on. If it's Jonathan Cohen who would be taking the case, what I would say is before granting the motion to withdraw, perhaps we can get Mr. Cohen on. I can just call him right now. He can log into your Zoom and you can sort out whether NDS is going to be appointed on the matter or not. I would venture to guess that he will not be ready to go on a homicide exam next week. But that would just be a guess just based on the voluminous discovery and our typical practices. But if the court would like me to reach out to Mr. Cohen or his supervisor, I'd be happy to do that.
I would like that. Thank you.
Yep, I got it.
But she is correct. The amount of discovery is, I mean, there's interviews that are 2.5 hours long, which takes almost 1.5 times that long just to get through the interview, take notes, and keep going on to the next interview and the next interview or whatever's next on the discovery sheet. Mr. Elsey did provide a discovery sheet that listed everything that's on that hard drive. I actually sent a 1 terabyte hard drive to the prosecutor's office for them to load the data on it, and he sent back with it with the sheet listing of all the files. And the sheet of files itself is 3.5 pages long. But the amount of discovery is incredible. It's the most I've ever seen.
Okay, I'll come back to you guys.
All right, thank you.
Mr. Dozy, good morning.
Morning, Judge.
Ready on Sparks?
Mr. Sparks, as I indicated, is in custody, and I know Mr. Sparks would want to be present, so I can pass until the jail zooms in with Mr. Sparks.
Okay, Mr. Taylor, good morning.
Morning, Your Honor. I have
Here on,
Patterson, yes.
okay. Ready on Patterson.
Calling case number 2305-779701 before the state of Michigan versus David Patterson. Defendant is charged in count 1, domestic violence, third offense. Count 2, unlawful imprisonment. Defendant has a two-offender before defense notice.
Corrections for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Edward Taylor appearing on behalf of David Patterson. My plea number is 57166.
What's your pleasure, Mr. Taylor?
If Mr. Patterson's not here, I waive his appearance, Your Honor. I'd like to set this for in-person exam.
Court will waive the defendant's presence, continue to plead not guilty, and set this matter for preliminary examination on July 24th at 10:15.
Yeah, that should work, Your Honor. 10:15, I got it. All right, thank you.
All right, thank you.
Thank you, Judge.
Thank you. Mr. Simon.
Morning, Judge. I'm here for Eric Montgomery. He's on a personal tether bond, but the jail records indicate he's still incarcerated. I did meet with him last week, and I know that he wants to have the matter set for examination.
You're gonna waive his presence?
Yes, Judge.
Let me call the case.
Calling case number 2305-766901 for the state district versus Eric Montgomery. Defendant is charged in count 1, assault with a dangerous weapon. Count 2, weapons carried concealed. Count 3, weapons felony firearm. Count 4, domestic violence, second offense notice. Count 5, malicious destruction of personal property. 200 more but less than 1,000.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Jonathan Simon, P35596, on behalf of Mr. Montgomery, who apparently is still in the custody of the Wayne County Sheriff. I would ask the court to allow me to waive his presence for the purpose of setting the matter over for preliminary examination.
Court will waive the defendant's presence, continue to plead not guilty, and set this matter for preliminary examination. July 24th at 10:30.
Judge, I will be in trial that morning with Judge Slavens.
What about the afternoon?
Well, I know the trial's not going to go, so yeah, I guess I would be available that afternoon.
Okay, July 24th at 1:30.
Thank you, Judge. I'll see you then.
All right.
Take care.
Ms. Pilkowitz.
Morning, Judge. I have spoken with Mr. Cohen as well, who spoke with our supervisors. NDS is not taking the case as community intake. So to the extent that that solves any confusion, we are not going to be representing the client at this point.
What case are you here on?
I'm here on Mahogany Norfleet. My prosecutor is Mr. Hitz. Oh, and I see him.
Some these cases, they got a wounded. We don't do this. So this got to be submitted to clean. So when you do the property, see we got the range. Calling case number 2206-01-0701. People of the state of Michigan versus Mahogany Norfleet. Calling defendant is charged in the amended information count 1, operating while intoxicated causing death. Count 2, reckless driving causing death. Count 3, operating license suspended, revoked, denied. Defendant has a felony commission with the motor vehicle advisory.
Appearances for the record, please.
Good morning, and may it please this honorable court, APA Jonathan Hitz appearing on behalf of the people, P85288.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, PA 1653 on behalf of Mahogany Norfleet. I'd ask that the court waive her presence for purposes of this proceeding. I have been in regular communication.
For the way the defendant's presence. Okay, so my understanding is that circumstances have changed to where this now falls on my docket because we have a decedent. Is that right?
I'm sorry, Judge, you cut out a little bit on my end, but yes, this case was initially signed by our General Warrants Division because the victim had not yet passed away. The victim did pass away several days after the warrant was signed, causing our office to make the decision to amend the charges from reckless driving and operating while intoxicated, causing serious injury to both of those counts, ultimately resulting in a death. Therefore, I informed Judge Sabri about that, and that if it had initially been signed with those charges, this case would have been proceeding before you, Judge King. Left to her discretion as to what to do. I believe she contacted your chambers, and it was decided that it would be transferred to you. I did receive some.
I have a problem with the transfer, but the case still has to flow through the proper channels, meaning that it has to go through our criminal division and be signed off by your officer in charge, as well as, I guess, essentially as submitting another warrant.
That's not how I've done it in the past, Judge, but if that's what the court wants me to do, I'd be happy to do that. In the past, I've just provided the defense with notice because I'm able to amend the charges at any time. But like I said, I'm happy to accommodate the court however the court would like me to handle it.
Yeah, we have to flow through the proper channels.
I just couldn't find a Michigan court rule or anything on point. So if someone could explain to me what the court's view of the proper channels are, that's all I'm looking for.
All right. Have you get in contact with Ms. Jackson, the 36th District Court? It's in our criminal division. I'm getting her number for you right now. Okay.
I believe Miss Arnita may have sent that to me, so I think I have it. I've just been out of the office, so I haven't had a chance to reach out to her, but I'd be happy to do so.
Okay. In the meantime.
And Your Honor, I take it if a new warrant is going to issue and she's going to need to surrender, I know Denise Jackson is the person who handles the arraignment felony docket as well. Would it be possible, would the court, I guess, have any objection to doing the arraignments at the courthouse as opposed to having her surrender to the Detroit Detention Center? And could the court note that in the file? I ask because there are different restrictions and policies about who can walk in to the courthouse and who cannot. However, I imagine a judge's order or note indicating that the court has no objection to her appearing in courtroom 134 for her arraignment, as opposed to surrendering to the DDC, could go a long way with regard to scheduling.
Ms. Jackson. Right. No, this just go with formality of being it's definitely Ms. Jackson. She's saying
all right, I'm gonna have you take that up with Ms. Jackson as well. Whatever the procedure is. I really don't know. I don't have anything to say.
I'll raise that with Miss Jackson, Miss Pilkowitz. And
it doesn't make sense that she would have to turn herself into the DDC. She's already been processed from the initial time, so she shouldn't have to go back there again.
Thank you, Judge. So Mr. Hitz, I'll just look out for your email with regard to, are you going to move to dismiss this case today and then reissue? Is that the plan?
I certainly don't think I should have to dismiss this case, and I think that would definitely result in us having to rearrange your client. Let me contact Miss Jackson and see what she says. I've amended charges this way 3 or 4 times in the past, and I've never had this issue. I've even amended informations on the day of exam, so I'm a little bit confused, but I'll contact Miss Jackson and see what I need to do.
All right. Thank you. Appreciate it. Mr. Martin, good morning.
Good morning, Judge King. I'm here on the Wesley Gilmore case. This was originally being handled by Attorney William Swore, but he's unable to proceed. The family's unable to afford him. Mr. Gilmore is a former NDS client, so we would like to take him on. And I emailed the court last night with stipulation and order for substitution of counsel, as well as a discovery order. This is a homicide case.
Calling case number 2305-764101, people of the state of Michigan versus Wesley Gilmore. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, weapons, firearm, possession by felon. Count 3, weapons, felon, firearm. Count 4, weapons, felon, firearm. Defendant has a habitual offender for defense notice.
Appearances for the record, please.
Good morning again, and may it please this honorable court, APA Jonathan Hitz appearing on behalf of the people, P85288.
Good morning, Judge King. Good morning to your staff. Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. Wesley Gilmore. I believe Mr. Gilmore is at the jail, which is not zoomed in yet.
Did you want to wait on him or wait his presence?
Your Honor, maybe we should wait on him, given that we might be handling a substitution of counsel and okay.
Mr. Toussaint.
Yes, Your Honor. I've been retained on Eric Montgomery.
And we just did Montgomery. Mr. Simon set it for exam on July 24th at 1:30. Are you available on that date?
I'm not available on the 24th, but I'm available on the 25th.
25th is my homicide day.
Let me check and see if I can be available late in the afternoon if the court is available.
Okay, I have it set for 1:30 so far.
Judge, right now that keep it for 1:30. Let me just make certain. But Mr. Montgomery, I believe, is at the jail as well.
All right. Would you want to wait his presence to a substitute?
Judge, can we bring him on if possible?
Okay, the jail isn't here yet.
Judge, I'll wait.
Okay. Here they come now.
Thanks, Your Honor.
Wayne County Jail, are you there?
Good morning, Judge. How are you?
Good, how are you?
Not bad. We got 2 scheduled for you today. Diana Evans and Jovan Stark.
Okay, I definitely need Sparks. I also need a Montgomery and Gilmore.
Eric
Here comes jail.
Eric Montgomery, you're
Yes, Eric Montgomery.
And the other name you said was Gilmore?
Yes.
What's the first name?
Yes.
Okay, one moment.
Mr. Clemens.
Good morning, Judge.
Good morning. Cunningham has been transferred to Judge Jefferson.
No, I object vehemently.
Line draw.
Okay,
As you're probably aware, I'm very close to the defendant's family.
yes. I just was hoping for a different outcome than that. Should I go there now?
Yes, sir.
Okay, thank you. See y'all later.
Have a good day. Turn out good. What are you talking about? Oh, sure. Come on, sure. Yeah. I do it. Yeah. Oh. It looks like we're at a standstill until I get the prisoners. Ms. Johnson, what are you here on?
Morning, Judge. I have Mr. Sparks.
Mr. Makepeace, what are you here on?
Morning, Judge. I'm here on a two defendant case, Addie Smoot and Wayne Owens.
Okay. Haven't seen either of those attorneys yet. Ms. Biggerstaff, what about you?
Good morning, Judge. I have Diana Evans.
Okay, I don't know who's standing in for Mr. Toes, if anyone. Oh, that's right, that's right. Okay, so we need to see Ms. Evans to see if she's hired by the counsel. She indicated that she would. Mr. Donnie, let's go back to you.
All right.
Okay, so back on the record on People versus Brazer. So, not sure if you heard that from NDS, but they said they're not going to take the case.
Yeah, I heard that. I'm not sure what changed from that July 6th. Maybe it's the workload involved in the case. Maybe it's the amount of discovery. I do know that when I spoke to Mr. Cohen last, he did inquire about how he would be able to get the case, but I'm assuming their workload must have changed, or I'm not sure what their change of mind is. A couple of issues I have is that
It's not discussed July 25th. I believe I said it at 9 o'clock because of the sheer number of witnesses involved.
I think there's going to be 13 to 17 is my understanding.
I think at one time be over 20. But nevertheless, court understanding that you have quite a bit of discovery there, I'm willing to grant an adjournment to give you more time to review that discovery.
Well, my concern is not only that, because I just received additional discovery yesterday, but it's the assistance that this case is going to require more than one person. The odd thing is here is that, timing, I guess, is everything, but had this not moved from the 29th, the arraignment, to the 13th, I wouldn't be in this position, because I would have known at that point that the family cannot afford the resources necessary to retain the resources necessary to have attorneys handle this case, and they would.
That's a mistake. That's a mistake that young attorneys make.
Yeah, well, that's
don't know to get your money before you file an appearance.
Well, Judge, I never filed an appearance. That's what I'm saying. Had this not moved, I literally got called about this case on the 13th. I think it was your clerk said, "Hey, he's getting arraigned in like 5 minutes. You need to log in." And I'm like, well, if I don't log in, he's going to have no attorney at arraignment. Now, if we were stayed at the 29th, I would have not been in this position, because I would have known by then that there is no funds available to retain somebody. I only joined the arraignment. And I've never filed an appearance.
Why was it so pressing for you to appear at the arraignment?
Your office called me and said, I'm told you're going to be the attorney. He's getting arraigned. You need to log in. And that was from, I guess, Miss Reynolds called me. And because I didn't even have a Zoom number. She gave me the Zoom number.
Ms. Reynolds called you and told you to appear? I don't think so.
No, she called me and said, he's being arraigned. Are you his attorney? And I said, well, I guess I'm the only one available. And because I had called looking for Zoom number. When I found out he's being arraigned that day, I had no Zoom number. And I was calling around looking for a Zoom number. I found Mrs. Reynolds. I left her a message saying, I guess he's being arraigned today. I just found out today. And she goes, yeah, it's going to happen in about 5 minutes. Here's the Zoom number. And that's, like I said, though, had this stayed with the 29th, I wouldn't be in this spot, because I would have declined representation, period, when I would have found out that they can't afford the resources necessary. And I'm not talking just me. I'm talking they need at least 2 attorneys on this with a support staff, which would be, my admin. But they can't afford that, and they just can't. Now, it took them a long time to try to get money, which I'm not happy about, because it took them so long to finally say, no, we're not going to be able to get it, because in the beginning they said, oh, no problem, we're going to get a bank loan, blah, 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 blah. Well, that never happened. They dragged their feet, and here we are. I'm going to be put in a position where I'm going to be forced to take a retained case that I don't have the resources for, and there's absolutely no money for. And I'm going to be in a position to where if something goes south, and let's say I miss something through all that discovery, and he ends up in jail for 30 whatever years, I'm going to get sanctioned, as sure as you know it. And I'm not willing to put myself in that position. And I don't want to put Jalen in the position where I make a mistake because I'm rushing through all this discovery and he ends up paying for it. I mean, that's not in the interest of justice. I think my idea of withdraw me, let him get a retained counsel or a court-appointed counsel. I will contact that attorney and offer my services to be second chair. And it's way easier for him to petition a second chair that way than it is for me to ask for it as a retained counsel, because they automatically think, oh, you're retained, then they can afford everything. Now, if the request comes from a court-appointed attorney, it's way easier for the MIDC or whoever's in charge of the funds to grant money for additional help. And that's why I think this is the best path for everyone involved. And that way, nobody's putting themselves in a position to, get sanctioned, or Jalen putting himself in a position where he's going to feel like he's not getting the help he needs or the representation he needs because I'm taking this on and it's I don't have the resources.
So essentially, maybe I should appoint additional counsel to assist you and give you an adjournment, get that counsel up to speed, as well as give you an opportunity to review the balance of the discovery.
You know what? That's another option. I'm easiest path moving forward. I mean, I'm still going to be taking on a case where I'm going to be paid virtually nothing for about 250 plus hours of work, but I'm not really happy with that either. What's that?
I don't want to lose you. I was looking forward to seeing you work.
Well, you know, like I said, in the perfect world, we would have stayed on the 29th. I'm not sure why I got put ahead that much as far as the arraignment goes. I mean, I guess dates always change.
The time and they have to arraign them within 72 hours.
Yeah, I don't know why. It's in my calendar for June 29th. I'm not sure I was getting that date, but it is what it is. I'm not going to worry about that little minutia crap.
Okay, yes, I'm going to appoint additional counsel. I'm gonna call over to the assignment clerk, get another attorney on it with you. And I'm going to put it out for at least 2 weeks, maybe 3.
Well, the longer the better. Now I gotta say, you know, okay. I guess I get to work. You get to see me work for free. Because the other way, if you withdraw me and appoint somebody else and I join the team, the MIDC would pay me and I would at least get something.
Whatever, I want you to stay on it. August 7th.
So I will stay on it by joining the appointed counsel.
Okay. August 7th. I'm sorry, August 8th. I can do 10, 11:30, or 1:30.
Judge, again, this is, I think when we were set for the 25th, we were penciled in for an all-day event, given the volume of witnesses. Would it be possible to stick with that plan?
Okay, 9 o'clock, August 8th.
Thank you, Your Honor.
Does that work for you, Mr. Dowdy?
Yeah, and it's, but not to correct my name's Dodie.
Dodie, I'm sorry, Mr. Dodie.
No worries. Everybody does it.
Draw and join the defense team once someone is appointed.
Excuse me, say that again, please.
So I want to withdraw from the case so you can join the defense team so you can get something for your effort.
Thank you very much, Your Honor. I appreciate that. And I actually want to be part of this case too, because I think it's got some meat on the bone.
Okay. August 8th at 9 o'clock.
Thank you, Your Honor. Appreciate it.
Thank you, Your Honor.
You have a good day.
Another attorney for Brazer. Sign. Who's this we have in the Wayne County Jail? What's your name, sir? I can't hear you. Let the deputies know I can't hear you, sir.
It's Mr. Sparks, Judge.
That's Mr. Sparks, okay. Do we need to hear from Mr. Sparks, Mr. Dozie?
No, we've spoke. We're ready to go, but I believe that he might want to participate in some fashion. So if we could have the deputies change his mic, that would be great. And I
can't hear you, Mr. Sparks.
Can you hear me now?
Yes, sir. Now I can hear you.
Morning.
Okay. Let's recall Sparks.
Call in case number 2305-780601. People of the state of Michigan versus Joe Bond Sparks. Defendant is charged in count 1, criminal sexual conduct, 3rd degree. Count 2, criminal sexual conduct, 3rd degree. Count 3, criminal sexual conduct, assault with intent to commit sexual penetration. defendant has a habitual offender second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
And good morning, Eric Gozzi on behalf of Mr. Sparks.
Tell us your name again for the record, Mr. Sparks.
Jovan Sparks.
What's your pleasure, Mr. Dozie?
Judge, we have received the discovery. We are just need to schedule a date. Unfortunately, the date that was originally planned does not necessarily work for the defense. Well, doesn't work for the defense, as I will be in a jury trial starting next Monday on another CSC case. I spoke with Ms. Johnson, and we have a preliminary date possibly of the 31st or August the 1st if the court is available.
Why do we have to go so far out?
Well, my trial is scheduled to take approximately 3 to 4 days. I'm available on the 27th if the court is available, but I don't know about Ms. Johnson's schedule at on that day.
That's my homicide day.
That's another concern too, Judge. I'm
Okay,
available. I'm also available on the 28th in the afternoon.
I'm sorry, Judge, I already have one on the 28th in the afternoon.
I'm sorry?
It's out county, out in, I'm sorry, Judge, I have one on the 28th in the afternoon. I can't remember where, but I know it's out county. It's not in your court.
What about the 26th?
Again, Judge, I will probably still be in trial on that day.
Trial's gonna take a week and a half for CSC?
No, it should take 3 days. It starts on the 24th and it should be concluding by the 26th. Yeah, we were already that far into July.
On the 28th, but Ms. Johnson's not.
That's correct, Judge.
'31st?
31st is perfect for the defense,
And I'm open all day on the 31st, Judge.
as am I.
Okay, the 31st at 10 o'clock.
Perfect.
We continue.
Well, if I could address that, if I could, Judge.
Okay.
Thank you, sir. We did, in all honesty and all candor, we did appear for, and I personally appeared for the bond redetermination hearing before Judge McConaughey. And bond was continued at the $200,000 cash level. Possibly speaking on behalf of Mr. Sparks is that he does not have a KBS history. The allegations against him are one of a statutory rape, no indications that there was any force, coercion, or anything untoward in terms of that nature. It's straightforward. Age is the only issue. Now, the people, of course, want. Forgive me?
How old is the complainant?
He was 14 at the time, Judge.
Okay.
Without getting too much into the details of the case, it would appear that from reading the discovery and reviewing the investigator's report only, that the complainant, and Ms. Johnson will pipe in if I say something out of turn, that the complainant was seeking an individual on an adults only chat website, in which an adults only dating website actually. And by admissions of family members, he and the complainant himself had indicated to the person that he was indeed an adult and a female. And then upon his arrival, our contention is that nothing happened. People's contention is that something did. This was reported, I believe, approximately a week or two after the first initial encounter that's alleged. However, our contention is that that was the only time that there was any contact between the two parties. The people's position is obviously more than that. In fact, the complainant claims that he didn't do this just once, but he then returned a week or two later. And again, a sexual encounter had occurred between the two parties. No DNA was done, I don't believe, nor was there a sane report done on this case as well. Again, Mr. Sparks has one prior on his record for child support, failure to pay child support, which is a felony, to be sure, but no adult or juvenile record that I'm aware of, nor has he ever missed any court dates that's been brought to my attention. The $200,000 cash bond is clearly outside of this man's means. He had been employed of sorts. He was working as taking care of an adult foster care facility, house, if you will, where he was given room and board in turn for his services of caring for these adults. Therefore, Judge, I would think that the bond is well outside this man's means. I would ask the court to consider a reduction in bond.
Ms. Johnson?
Thank you, Judge. That is correct. The allegations in this case are that a 14-year-old child was on some kind of adult dating website, interacted with this individual, and then rode his bike to his house on more than one occasion. The people will leave the bond in the discretion of the court.
What circumstances have changed since the bond redetermination hearing that he had?
Well, Judge, he is terribly concerned about his employment, and what was most telling to me was that his first concerns to me was to make sure that his employer knew that these people would not be able to have somebody to care for them in his absence. In other words, who's going to feed them? Who's going to make sure that they're getting their medication, etc. I don't believe that Judge McConaughey was well, I know Judge McConaughey was not made aware that I wasn't given the opportunity to advocate as. I'm sorry, Judge.
I'm sorry.
How long has he been in jail?
He's been in since I want to say July the 1st, which would have been, I'm sorry, not July the 1st. The date of the call from the police was July the 8th. So he's been in for about 10 days now.
So you're not telling me these people haven't eaten in 10 days, are you?
I don't, honestly, Judge, I do not know. I reached out to his employer and the phone was, I was told that the phone is not set up for voicemail at this time.
So he engages in, allegedly, he engages in criminal sexual conduct with a 14-year-old boy.
That is correct, Judge. Those are the allegations.
The prior is failure to pay child support.
That is correct, Judge.
Yes, Judge.
And the kid came to him.
That is correct. Twice.
His father said 200,000 cash.
Yes, Judge.
I'll reduce the bond to 200,000, 10%. GPS tether, no contact with any child under the age of 16.
Of course, Judge. Oh, it goes without saying. Thank you. We appreciate that, Your Honor. We look forward to seeing you on the 31st. And
Thank you, Judge. Have a good day.
And that was at 10 o'clock. Is that correct, Your Honor?
Yes. July 31st.
Will do. Thank you, Judge.
Thank you.
Everybody have a wonderful day. Mr. Sparks, I'll reach out to you soon.
You're all set, Mr. Sparks. Mr. Toussaint. What's your name, sir? Wayne County Jail. Unmute yourself. Oh, that's a man. I'm sorry, that must be Miss Evans. Unmute yourself, Miss Evans. There you go. Are you Miss Evans?
Yes.
All right, Miss Evans, did you get another attorney?
Yes.
Please.
Quentin Dots the second.
Spell the last name for me.
Dots the second. DOCKS Dots.
Oh, Mr. Dox. Okay. I haven't seen Mr. Dox this morning, so hang on for me, okay?
Okay.
Mr. Toussaint.
Yes, Your Honor, I'm still here.
Okay, and you are here on, who is it again?
I'm here on Eric Montgomery.
Oh, that's right. Were you able to verify that date and time?
I think that date and time will not work.
Okay, tell me why.
I already have a matter in Macomb Circuit on the same date that was set prior to this date. I have a preliminary examination in Allen Park in the morning at 10:30 that may last for about an hour and a half, 2 hours. I just don't want to just press the issue and try to do this and not be, if we could do it later in the afternoon, because I believe the matter in, the matter in Macomb Circuit probably won't take that long, but I just don't want to, not be available.
What about 11:30?
11:30?
Yes, sir.
I probably will still be out in Allen Park on that exam, Your Honor.
I can go as late as 12:30.
I tell you what, let's set it for 12:30 on the 24th.
Okay. Recalling.
I don't think he's in the Wayne County Jail. I was waiting for him to appear.
Oh. I'll come back to you. Mr. Holler, are you still in here? He's in the hallway. Okay. Wayne County Jail. Wayne County Jail.
Yes, Your Honor.
Do you have a Mr. Montgomery for me? Eric Montgomery?
So, how is the case, it's a 2-defendant case with Owens. They're telling me that they can Your Honor, if you need Eric Montgomery, I can bring him down, but I was informed he was already done.
Yeah. Yeah, he was. Turns out he has a different attorney here. We're just changing the date. Mr. Toussaint, Mr. Montgomery was here earlier today.
Yeah, can we bring him back out since I know that, he's retained me. So I want to show him my face and show him that I'm here for him.
Wayne County Jail, who is in Annex High MC2? What's your name, sir?
Wesley Gilmore.
Yeah, we're ready on Zoom.
Calling case number 2305-764101, people of the state of Michigan versus Wesley Gilmore. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, weapons, firearm possession by felon. Count 3, weapons, felony, firearm. Count 4, weapons, felony, firearm. Defendant has a habitual offender or defense notice.
Appearances for the record, please.
Good morning again, and may it please this honorable court, APA Jonathan Hitz appearing on behalf of the people, P85288.
Good morning, Judge. Good morning to your staff. This is Carrie Martin from Neighborhood Defender Service. We are seeking to be appointed as counsel for Mr. Gilmore. My P number is 84592. And Mr. Gilmore, please state your full name for the record.
Wesley Gilmore.
All right. What's your pleasure, Mr. Martin?
Well, Attorney Bill Swore was originally appearing on this case. However, he never filed an appearance, and he did so on a pro bono basis. And Mr. Gilmore and his family are unable to afford Mr. Swore's services. So I've spoken with Mr. Swore. He would like to withdraw from the case and would like to have NDS step in. Mr. Gilmore is a former NDS client, so we are seeking to be appointed in this case. My senior colleague, Lisa Frederick, would be primary counsel. I would be secondary counsel.
My understanding is you've already sent over a substitution of counsel, is that right?
That's correct.
All right. So order. And I presume you want an exam date, is that right?
That's right. We don't have any discovery yet, and it sounds like Mr. Swore never received discovery either. So if we are going to set an exam date, I would ask that it be at least 2 weeks out. Perhaps it'd be better to just set a PCC date to make sure we get the discovery. This is a homicide case, so that we can plan accordingly for the exam.
I'm very aware of what kind of case it is, sir.
Yes.
Mr. Hitz, when are you going to get the discovery to counsel?
Well, I was just informed that Mr. Martin was retained in, yes, well, not retained in, but is attempting to become appointed for the defendant yesterday. I was on vacation. I would like to have a quick discussion with Mr. Martin about the possibility of a protective order, but assuming we can get an agreement to that, then I could have discovery to him very quickly. I'm prepared to send in this case.
Mr. Martin?
And I'm more than happy to talk with Mr. Hitz just after this hearing to work that out. So if discovery is forthcoming, then perhaps we could get an exam date. I heard some of the dates you were throwing out on a previous hearing. I'm looking at my calendar as well.
It looks like I'm wide open for July 25th now.
25th.
I started jury trial on that date, Judge. I can't do the 25th. I'm sorry.
I have about 5 hearings that day.
Exam scheduled for 9 o'clock on the 25th.
I'm sorry, Judge. I'm triple booked with other hearings that day. I can't do the 25th.
Mr. Hitz.
I'm sorry, Judge.
How are you going to do that lengthy exam that was supposed to start at 9 o'clock if you're already going to be in the jury trial?
I don't know what you're referring to, Judge. Maybe Mr. Elsey is who you're thinking of? Because I definitely don't have an exam scheduled before you on the 25th.
I am thinking of Mr. Elsey, I'm sorry. So you're not available on the 25th. When is your jury trial starting?
It starts on the 25th. I would expect it to go through at least the 27th, probably into the 28th.
August 1st?
I'm available that day.
Your Honor, I can probably do August 1st. I have a trial of my own that starts on the 31st, the day before. It could be a one-day trial. It could stretch into the second day. If we were to do August 2nd, that would be wide open for me.
Only problem is that's not a homicide day. How about August 3rd?
August 3rd? August 3rd would be great. Yes, if we could do August 3rd, that's excellent.
August 3rd at 10 o'clock?
That works for me, Judge.
Thank you, Judge.
We continue. Thank you.
Thank you.
Thank you. Mr. Hitz, I'll get into contact with you.
Thank you, Mr. Martin.
Take care, Judge. Have a good day.
Thank you too.
And Mr. Gilmore, we'll come talk to you again soon.
And Judge, I'm gonna stay on the Zoom I don't know if he contacted you, but Mr. Miller told me he wanted to zoom in for an issue with Tavares Brooks. It's the exam that you have set for 1:30 on the 20th. So this coming Thursday. So I don't know where he is. He told me he's gonna be here at 8:30. Yeah.
Brooks is scheduled for today. Marcus, oh, I'm sorry, that's what, never mind.
You scared me there, Judge. I have it on my calendar for Thursday at 1:30.
Okay.
But I think there might be some issue Mr. Miller wants to bring to the court's attention, so I'll stay on.
Wayne County Jail. What's your name, sir?
How you doing? Eric Montgomery.
Oh, this is Mr. Montgomery. Okay, where did Mr. Toussaint go? There he is. Mr. Toussaint.
Yes, I see you have my client. Thank you.
All right, recalling 230576691 people versus Eric Juan Montgomery. Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And Judge, may I please this small sound of record Vincent J. Toussaint on behalf of Mr. Eric Montgomery, who appears today at the Wayne County Jail, Your Honor.
So, tell us your name for the record, Mr. Montgomery.
Eric Montgomery.
So, sir, I understand Mr. Toussaint is now your attorney. So we have scheduled your preliminary examination for July 24th at 12:30.
Thank you, Your Honor. And just one more thing. Your Honor, my client was given a $50,000 personal bond with a GPS tether on Thursday of last week. He is still currently at the Wayne County Jail. I've tried to contact the tether unit to no avail. I was trying to see if there's anything that this court can do to make certain that hopefully my client can receive the tether, since he's just really languishing at the Wayne County Jail. And he has a bond. I hate that he's still over there since Thursday of last week.
So my understanding is that there may be a shortage of tethers. I don't have any tethers to give.
Mr. Montgomery?
Yes.
Have you been contacted by the tether unit regarding your placement of tether yet?
Yes, sir. Yesterday.
When?
Yesterday.
When did they say your tether will be placed on?
The address?
No, when did they say you will be given a tether?
They didn't say. They just came with the I just filled the verification paperwork out.
So it sounds like it's soon, Mr. Toussaint.
Yeah. Well, hopefully he's, Judge, I'm praying that he's out before the 24th.
Okay.
All right, Mr. Montgomery, I'll check with the tether unit again, and hopefully we can get you out as soon as possible, okay?
Okay, because I know I have a job now I'm trying to keep.
I understand. And we're trying to make sure that you keep your job.
Okay.
All right, thank you, Your Honor.
Thank you. Have a good day, Mr. Toussaint.
You as well.
Thanks, Toussaint.
This is 12:30 on the 24th. You're all set, sir.
And that's tomorrow's rules. I had that for tomorrow.
Brooks or Brooks?
The one, the attorney wants to.
Mr. Hicks is still here. But it wouldn't be tomorrow. I'm sorry.
No, the attorney wanted to talk about something. He asked me to put it on the docket.
Oh, it's on the docket for tomorrow. Okay. Mr. Hicks.
Yes, Judge.
So the attorney contacted the court and asked for it to be put on the docket for tomorrow to address whatever issue he has.
Okay, he told me he was gonna appear today, but I'll contact him. I would prefer if we could address it today, so I could let my witnesses know if this exam is gonna go. But I'll talk with him.
Okay, we'll see if we can get in contact with him. I have time today.
Thank you, Judge. I appreciate it.
Hey, Mr. Hitz, could you also tell him that that's Jay Grant Miller you're looking for?
Yeah.
Can you tell him he still needs to zoom in on my case?
All right, I'll let him know.
Thanks.
Sounds like he's needed anyways, Judge.
Kill two birds with one stone. Because Mr. Holler is here in court.
Mr. Holler's in person, Judge?
Yes, he just stepped away.
Okay, this is probably a case that we should call together. It's a reissue and there are some issues.
Oh, yeah.
Okay,
That's my intention.
thank you.
This is Ursula Smith.
That was the witness. I just had to keep it on.
Knox is the attorney for Owens and the senior Knox. Still waiting on your attorney. So. You'll see it. Oh, look under the 22. This is I you on the back of the 22. Here's Mr. Knox. Good morning, Mr. Knox.
Good morning, Your Honor.
You're here for Ms. Evans, right?
Yes.
Calling case number 2305-709701. People of the state of Michigan versus Diana Evans. Defendant is charged in count 1, homicide, murder, second degree, count 2, weapons, felony, firearm.
Appearances for the record, please. The speaker staff, are you there? The speaker staff indicated she was in trial. Let's get your
Your Honor.
appearances.
Yes, good morning, Your Honor, and Your Honorable Staff, Attorney Quentin Dox, P number 79657. On behalf of my client, Ms. Diana Evans, who appears via Wayne County Jail. Ms. Evans, if you can hear me, please state your full name for the record.
Diana Evans.
All right. Your appearance, Ms. Bickerstaff? Your appearance, Ms. Bickerstaff? Your appearance, please, Ms. Bickerstaff.
Good morning, Your Honor. Anna Bickerstaff on behalf of the people, P82215.
All right. Mr. Dox?
Your Honor, I have just been retained on this case, Your Honor. I wanted a chance to speak with Ms. Bickerstaff. Can we get a week PCC adjournment?
Why do you need a week?
Well, whatever available for the court, Your Honor. It's ASAP though, but it's whatever is available for the court in your schedule.
I'm here every day.
You want to do this Friday, Your Honor? If that's okay with you?
That's fine.
Okay.
Turn the PCC to Friday, July 21st at 8:30.
All right, appreciate you.
Thank you, Judge.
Thank you, Your Honor. We'll talk Ms. Evans.
Okay.
You're all set, Ms. Evans. Thank you.
Okay, I got one.
Okay.
No. Yes.
Still no word from Mr. Bradley. Sorry. No, sir.
Hey, Judge, I have a couple other courtrooms to be in. If Mr. Miller does appear, he has my cell phone and he can text me and I'll just hop back on or come back up to my office if that's okay.
Okay, that's fine.
Yeah, just let him know and I will be here as soon as I can. Thanks.
Thank you, Mr. Makepeace.
Since he also has my cell phone, do you mind if I hop off and take advantage of that same deal?
No, that's not okay, John. You can't do that.
All right. See you later, Mr. Hicks.
Thanks, Judge. Have a good one.
You too.
Is 49263. Issue. Two different terms. What's the other case? Brooks, Barnes Brooks. through 11:30, it was just one witness, right?
I think so. Yeah, one identified, should take 10 seconds. The last two. You sure? No, you're not. It's in the standstill. Oh. And what's your name? Sorry, I don't think I met you.
Allison.
Nice to meet you, Allison.
Nice to
Thank
meet
you so
I
much.
don't think I've ever worked for you before.
No, I don't think so.
All these years.
Thank you very much for this meeting. We appreciate it.
Sure. I'll be right
section.
So. And people just have something to substitution. Yeah.
Okay. So, so
Those parties still on the line?
yes, they are. The
They can step. Mr. Miller. Trying to find this attorney, Judge. You still got it. How you doing, Mr. Howard? Appreciate your patience, sir.
sure, yeah.
Mr. Miller.
So Mr. Miller is doing. Yeah, Judge, perhaps it would be a courtesy for me to tell you that I think that I can give you a history of the case at the appropriate time, but I think I'm going to be asking to allow me to withdraw. So I would probably tell you that rather than, since we're waiting on everybody, I can give them, and I know Mr. Makepeace isn't here, he probably should be, and I can go on the side, I'll be glad to, but why do you want to withdraw? Well, I think I took the case, and it was kind of concluded. There were this case was ready to go to trial. It went to trial, or started to go to trial July 10th, after being litigated for about 3 years. And Mr. Makepeace is the lead prosecutor on the case. He moved to voluntarily dismiss his case, refiled it the next day. And both of the original attorneys wanted to continue. I think that the case is going to be set to be, Judge Slayton is going to want to try this case when it gets up. At the very near future, he's going to want to try it. I'm still waiting to hear why you. I would guess. I don't think that I could properly fit it in. I think Judge Slayton, my guess is Judge Slayton's will want to fit this in. So is it, so I asked myself over the weekend, I just got this case on Friday. That may be something you might need to take up with Judge Slayton. I don't know what Judge Slayton is going to do or say. What do I know anything about this count? Sure. Yes, sir. Okay, all right. If it gets found over, right? Mr. Miller. Unmute yourself.
Good morning, Your Honor.
Sir, we've been waiting on you all morning.
My apologies, Your Honor. I
That's
just
all you
ran
got?
into Mr. Makepeace. I had put this matter down for tomorrow, which is why I had arranged to do Mr. Brooks tomorrow. It was my error, Your Honor. I apologize to co-counsel and to Mr. Makepeace already in person.
So I think both are up to date.
Yes, Your Honor.
Okay, so you have talked to Mr. Makepeace. I'm waiting on them to log back on.
He was walking into Judge Green live in person, Your Honor. I just saw him before Judge Nicholas Hathaway across the street, Your Honor. He was going to Zoom right back in.
Okay.
Has Mr. Hitz left, or is he still available, Your Honor?
He said, can you actually text him when you get here? He said you have his cell number.
I will attempt to text him, Your Honor, and if I unwittingly apologize if I hang up, I will reconnect to the Zoom. I'm not great with technology.
Okay.
Mr. Hitz and Mr. Makepeace have both responded and should be zooming in shortly, Your Honor.
Okay, thank you very much. Okay, here's Mr. Hitz. Okay. And what case does Mr. Hitz have with me?
Tavares Brooks, Your Honor.
Okay, let's call Brooks.
Calling case number 2305736701, people of the state of Michigan versus Tavares Brooks, defendant charged in count 1, homicide, murder, first degree premeditated, count 2, weapons, felony, firearm.
Appearances for the record, please.
Good morning again, and may it please this honorable court, APA Jonathan Hitz, appearing on behalf of the people, P85288.
Good morning, Your Honor. J. Grant Miller, P58658. On behalf of Mr. Brooks, I'd ask the court to waive his presence. He is in Wayne County Jail.
Court waive the defendant's presence. What's your pleasure?
Your Honor, it's come to my attention through my client's mother. My client is a paranoid schizophrenic. I would like to make sure his file is marked medical. She believes he's getting his medication, but I believe I need to ask for a competency and a criminal evaluation if he's a diagnosed paranoid schizophrenic, Your Honor.
Let me ask you this, Mr. Miller. Have you interviewed your client? Have you talked to him?
I've talked to him briefly on the phone, Your Honor. I have not gone to see him yet because I need to get the discovery from Mr. Hitz, which I was hopefully going to pick up a drive from him later today. I may still go see my client, but he has had a diagnosis and he does receive aid from the federal government based on his diagnoses. So I don't believe this is a stall tactic or some kind of game or theory.
That doesn't necessarily mean that he's not competent.
Correct, Your Honor.
So why would you be requesting a competency evaluation if you don't know yet? You haven't had an opportunity to converse with your client and make that finding that he's not understanding or appreciating the charges lodged against him or otherwise unable to assist you in this defense.
Your Honor, I'm happy to try and get the discovery from Mr. Hitz this afternoon, go visit my client and revisit this issue tomorrow morning. But my conversations with him on the phone, he does not understand reality.
Okay, that's different. So your representations to the court is that based on your conversations with him, you don't believe that he's able to logically assist you in his defense, is that right?
He did not understand where he was or why he was there, Your Honor, from my brief phone call. So I don't believe he'll be able to assist me in his defense.
He didn't recognize he was in jail?
He knew he was being held. He couldn't understand why he couldn't leave, and he thought it might be a hospital.
All right. And that's entirely different. The court will refer the defendant for a competency evaluation. We'll set a review date for, I believe, October 18th. Double check that date. October 18th at 8:30.
Yes, Your Honor.
That works for the people. Thank you, Judge.
All right, haven't seen Mr. Makepeace yet.
He may still be on the record with Judge Giovanni, Your Honor.
Okay.
Have a good day, everybody.
Thank you. You too, Mr. Hitz.
Excuse me, Kenneth.
Change this light bulb.
Okay,
Okay.
thank you.
Here's Mr. Makepeace. We're rating on Owens and Smith.
Calling case number 2305-7811, people of the state of Michigan versus defendant number 1, Abby Smoot, and defendant number 2, Wayne Quincy Owens. Both defendants are charged in count 1, homicide, felony murder. Both defendants are charged in count 2, child abuse, first degree. Both defendants are charged in count 3, child abuse, first degree. Both defendants are charged in count 4, child abuse, second degree. Defendant number 2 has a habitual offender, second offense notice.
Appearances for the record, please.
Good morning, Your Honor. Matthew Makepeace on behalf of the people, P82796, with respect to both defendants.
Good morning, Your Honor. John J. Holler, appearing on behalf of Ms. Abby Smoot. She's here in the courtroom, standing to the rear and to my left. Tell me your name for the record, sir.
name is Wayne Quincy Owens.
Your name, ma'am?
Excellent.
Then please remove the rag off your head.
And good morning, Your Honor. Jay Grant Miller, P58658 on behalf of the defendant.
What's your question, gentlemen?
Well, Your Honor, this is a refiling of a case that has been through litigation for 3 years. It's my understanding there's a lot of preliminary examination testimony from the predecessor case and quite a bit of discovery. I'd like to have an adjournment of the PCC to review that. Mr. James Anderson, I got this case on Friday. I've been in contact with Mr. James Anderson, his previous counsel, and he's got it. He said he's ready to meet with me when we can later this week or next.
Are you retained counsel? No. Is there any reason why Mr. Anderson isn't doing this or holding on to this case?
If there is a reason, I haven't asked him, but I do know that he took himself off of the assignment. The capital list, right after this case was dismissed, so he can go off of that, what you want. And
who was the original judge?
The original judge was the Honorable Judge Mark Slavens.
No, I mean district court.
In district court,
Judge Roberta Archer, Judge.
Judge Archer. So I'm wondering if this case should go back to Judge Archer.
And Judge, that was an issue that I was going to raise this hearing. There is a statute and some case law that I've actually been personally involved in before that does in some ways require a reissue to a subsequent examination to be done in front of the original examining judge. I think that would be appropriate unless both of the defendants personally waive that on the record here.
What say you, gentlemen?
I think we should go back in front of Judge Archer. I don't think it makes any sense to start all fresh.
I would agree, Your Honor.
I agree as well. So we're all in agreement. I'm going to reach out to Judge Archer, have you guys do a probable cause conference for her, and let her set her own exam date.
And in the meantime, Judge, I will, Mr. Haller is right. There is I would say, very voluminous amount of discovery in the form of medical records in this case that are in my possession that have been redacted. I did not know until this morning who the new attorneys were on the case. So I will begin sending that over via evidence.com.
Okay, well, give me a moment. I'm going to get you a date for Judge Archer, okay? All right.
Thank you, Judge.
Thank you, Your Honor.
You folks may be seated.
Let Judge
Yeah, it's in the paper.
Yes. Okay, back on the record on Owens and Smoot. Just got off the phone with Judge Archer. She gave the probable cause conference date of July 31st at 9 o'clock.
Check that real quick.
Your Honor, I'm unavailable on the 31st. I begin an in-custody homicide trial.
I'm gonna leave it to you guys to square that away with Judge Archer. So are you gonna give Judge Archer a call, let her know that that day doesn't work for PCC, or she can give you a different time that day? All right, thank you
I
guys.
presume we can do that, but while you still have this case in front of you, before you send it over, Judge, I think we should, it'd be a good idea to go over terms of the tether.
So I think I should let Judge Archer make those decisions. It's gonna be her case.
Okay, that's gonna be July 31st.
Yes, sir. All right, thank you, guys. Have a good day.
Thank you, Your Honor.
I'm sorry, did you say something else, Mr. Miller?
No, Your Honor, I was just gonna say if Mr. Howard could hang out in the courtroom for another 30 seconds, we could go ask Miss Judge Archer and hopefully find a better date.
Okay, so maybe go to Judge Archer's court. Not sure where the courtroom is.
Why not? Okay.
All right,
Sure.
thank you, guys.
Okay, all right.
Go ahead and send to Judge Archer then, Mr. Miller.
Judge, we're on next, may I get set up or do we have somebody in between?
I think you're next.
Very good.
Gentlemen, are we ready?
Yes, Judge.
Calling case 22 58934, people of the state of Michigan versus Mr. Kirkley Jr. Defendant is charged in count 1, homicide, murder, first degree premeditated. Count 2, homicide, murder, first degree premeditated. Counts 3 through 8, assault with intent to murder. Count 9, weapons, firearms, discharge, enter at a building causing injury. Count 10 through 18, felony firearm. Appearances for the record, please.
Good morning, Your Honor. My name is James Kehoe, and my phone number is 82812. Yeah.
And good morning, Your Honor. For the record, James Schlaf, on behalf of Mr. Kirkley, 30720.
Okay, this matter was held in part from July 6th and continued to today's date. Are we ready to proceed?
We are, Judge.
Yes, Judge.
How many more witnesses do we have left?
I think 4 at the most, Judge. Okay. There were, due to the complications from last time, Judge, I made sure that regardless of who showed up, we would be concluding today. So I subpoenaed a few officers as well.
All right. Call your next witness.
All right, this time we call Sophia Steen to the stand.
Yes. Okay.
Please give your name and spelling to the young lady seated there, ma'am. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please have a seat in the witness box right next to me. Pull that door open. Speak into that microphone that will be to your left, okay?
Thank you, Your Honor. Good morning, Ms. Steen. Could you again just state your name again, please, for the record?
Sophia Steen.
Thank you, Ms. Steen. And I want to draw your attention. Make sure I have the right date. Back to July 31st of last year, in the early morning hours. Where were you at that time, Ms. Steen?
At my residence.
What was the address of that location?
11624 Coyle Street.
Is that in the state of Detroit, Wayne?
Yes.
What was going on at that location that morning?
We were having a birthday party.
And you say we, who all was there?
Me, my nephew, Jalen, friends. Do I need to say their names?
If you can recall, and just first names is fine.
Jalen, Teresa. I'm sorry, I can't remember everybody.
It's okay. About how many people were around that house at this time?
10.
Okay. Where was everyone primarily at?
It was evened out, so some inside, some outside.
Okay. And what kind of neighborhood is Coyle, the street was on?
It's a good neighborhood.
Okay. Residential?
Yes.
Okay. At some point that morning, does something happen that brings you into court today?
Yes.
What was that event?
My neighbor across the street started shooting us up.
Okay, you say your neighbor across the street. Do you know the address of that individual?
I do not.
Okay, you say across the street. Where in relation to your house is the neighbor's house?
So this is my house right here.
And you're pointing straight in front of you?
Yeah, straight in front of me. This house is right here, like not even 10 feet to the right.
Okay, so it's straight out and then not even 10 feet to the right?
Yes.
Is that if you're looking out the front of your house?
Yes.
And would that still be on Coyle Street?
Yes.
Okay, now you said it was your neighbor. How long had you known this individual?
I lived there for 3 years, so the entire 3 years.
Had you seen this neighbor before?
Yes.
About how often have you seen this neighbor?
Every time he came and left.
And do you see your neighbor as you saw him, as you described your report?
I do.
Could you identify an article of clothing that he's wearing and where he's seated?
He's seated to my right with a green shirt on.
May the record reflect the identification of the defendant in this matter?
So noted.
And Ms. Dean, only if you knew at this time, did you know your neighbor's name?
No,
And you said that he shot up. What do you mean by that?
he came outside with a gun and started shooting.
Where did he come out from?
I don't remember.
Okay. Prior to the shooting, did you see where your neighbor was at any point that morning, I should say?
He had just gotten out of a car.
What kind of car was it?
I don't remember.
Looking at your statement, refresh your memory as it pertains to that point.
Yes.
You're going to show Mr. Schlopp, just for the record, the first page of his statement. Go ahead, approach. You may. So Ms. Dean, I'm going to approach with your written statement. I'm going to ask that you, page 1 of your written statement, ask that you take a look at it, read it to yourself for as long as you need, and then when you're done, please look at it. Okay? Did that refresh your memory, Ms. Dean?
Yes.
Okay, let me just take that back from you really quick. So what kind of car was it, Ms. Dean?
It was a dark colored Durango.
Did you observe anyone in that vehicle after you saw the defendant get out?
There was another, a driver
Okay.
there.
Did you know any of these people?
No,
After you saw the defendant get out of the vehicle, what happens next?
I watched him walk inside the house,
You say the house, whose house?
his house.
Okay, and then what happened?
He came back out with, I'm not sure if it was a rifle or an AR-15.
You say a rifle or an AR-15. Can you describe to the judge how big this firearm was?
So, it was about this big.
So you're holding your hands out parallel with each other,
Yes.
and that's about 2-3 feet, Mr. Schlopp?
Yes, I would say so.
So, did you see what color the gun was, Ms. Dean?
I did not even start.
Okay, after you observed the firearm, what's the next thing that happened?
He started shooting
Did you see where the gun was pointed when the shots were fired?
at a vehicle that was by his house,
Do you know what kind of vehicle that was?
a Durango as well.
Was that the same Durango or a different Durango?
I'm not sure.
Do you remember what color that Durango was, the one that was shot at?
Black?
So there's a black Durango being shot at. How many shots do you hear at this time? Or observe?
Countless.
After the shooting at the Durango, what's the next thing that happened?
I watched the defendant walk back inside his house. He disappeared behind the wall to the left.
When you say to the left, is that as you're looking at the house to the left?
So if you like looking from my house to his house, straight ahead and to the left.
So he disappears to the left, and then what do you observe next?
He comes back out with a rifle and starts shooting at my house and at the people that was at my house.
When you saw him come out this second time, you said with the rifle, could you tell if this was the same rifle?
No,
So you observed him come in, come out, and he starts shooting. About how many shots are fired at this point?
I have no idea.
Okay. When the shooting breaks out, what do you do?
I was in shock, so I was stuck. I was just standing there
Where were you standing?
in my front door.
What's the next thing that happens?
People were running, screaming, there was still gunshots going off everywhere. I remember my nephew pushing me down, Jalen. And I remember him getting shot, running to the back bathroom. So after I got up off the floor from him, pushed me down, he came back out the bathroom and fell in my arms. He kept saying like,
Without
I shot.
saying what was said, Ms. Steve. Only if what you said, okay, Steve.
Uh-huh.
So he came back to you, and then what's the next thing that happens?
He fell in my arm,
Was there anything on your arms?
blood.
At that point, had you suffered any injuries?
I had got trampled.
So where was Jalen at where when the shooting started?
The living room, I believe.
Other than the defendant, did you observe anyone else with a firearm that evening?
I don't remember.
Thank you, Ms. Steen. Your Honor, I have no further questions at this time.
Cross examine? Yes, please, Judge. Good morning. Ms. Dean, I believe you testified that there was a party that evening,
Yes,
and what time did the party begin?
I'm not really sure.
So did it start in the early evening hours or later than that?
It started early.
Okay, so you believe that you had about 10 guests, is that correct?
Before the shooting started, it was about 10.
Okay, did that number fluctuate during the evening?
Yes,
All right, but you think that there were 5 inside and 5 outside at the time? Incident, is that correct?
yes,
Now, this being a party where was alcohol available?
yes,
And did you partake in alcohol?
yes,
It's your birthday party?
no,
Someone else's?
yes,
And how much did you have to drink that evening?
not a lot.
And could you tell us exactly, if you can, approximately how much you had to drink?
A cup or two,
Cover 2 of what?
alcohol.
All right. And what time did you start drinking?
I'm not sure.
Was it earlier in the party or later, maybe towards the,
It was later towards the end.
okay. Did you have any other intoxicants?
No,
So you stated that you lived in this neighborhood for 3 years, is that correct?
yes,
And during those 3 years, you had an opportunity to know my client, Mr. Winston Kirtley?
I'm sorry.
During those 3 years, you had an opportunity to know my client,
To know him?
to see him?
Yes,
Okay. So how many times do you think you saw him over that time?
a lot.
Okay. But on this particular occasion, it was dark outside, is that correct?
Yes,
And what was the lighting like on Coyle Street?
they were bright like these lights here. We have street lights on that street.
Okay, what were the streetlights in proximity to your house and Mr. Kirtley's house?
I can't say for sure.
Okay. But it was still darker than it was in daytime, is that right?
Yes,
All right. And at a distance, even with the lighting, you're still able to make a determination as to who that person was across the street.
I'm sorry, can you repeat that?
Yes, I can. Even with street lights, were you able to make a determination because of the darkness, who that person was across the street?
Yes,
All right, and what distance would it be from where you were observing this to across the street?
I can't tell you feet wise or measurement wise. I don't know.
Okay, so was there anything blocking you? But I should state, where were you observing this from? Your doorway?
My porch, my front porch.
So you were outside, is that
Yes.
correct? Okay, so was there anything like trees or cars or anything like that that would obstruct your view?
No,
So you said that my client, you arrived home and had to be in Durango, is that correct?
yes,
And you said there was another Durango, is that right?
yes,
Did that Durango, the occupants of that Durango, have anything to do with your party that night?
no,
Okay. And did you observe when they arrived, when that car arrived?
I don't understand the question.
Did you see when that car arrived, that other Durango?
I did not.
Okay. Was that Durango blocking the drive of Mr. Kirby's house?
No.
Okay. And did the occupants of that car, as far as you can see, have any interaction with Mr. Kirkland?
No.
You didn't see anything like that?
No.
Okay. So let me back up a little if I may. How long before the shooting began were you actually on your front porch?
I don't remember.
Short time, long time?
I don't remember.
Okay. Would you remember if you were going back and forth from the front porch into the house before the incident?
I was actually going from the front of the house back to the porch because, like I said, I had people outside.
So you're saying the front of the house, you mean the front yard, the front lawn?
The front sidewalk.
So you say that you eventually saw somebody come out of where Mr. Kirkley lives with a firearm, is that correct?
No, not somebody, Mr. Curtis.
Okay. When you saw that, did you reach for your phone and start making a call 911?
No, I did not.
Did you call 911 during any time?
No, I did not.
When you saw the person with the gun across the street, did you turn your back at that moment and began to retreat into the house?
I was trying to get all of my people that were outside because he had just shot up the Durango. So I was trying to get all of my people that were outside of my house inside.
So your observation was somewhat distracted by trying to get those people to come inside. Would that be a fair statement?
Can you repeat that?
When you were trying to get the people into the house, okay?
Okay.
Was your observation distracted at that time?
No.
So you were still staring ahead?
Yes.
Okay.
I was looking back and forth.
And the people in the Durango, did you see them make any moves with guns or anything like that?
I did not. They had tinted windows.
They had tinted windows. Were the windows down?
They were up.
Were they up the whole time that you
Yes.
saw? That you saw there, were the windows up the whole time?
Yes.
So after the shooting, did you remain in the house?
No.
Did you go outside?
Yes.
And that was after the second shooting, I should say. You went back outside?
Yes.
And for what purpose?
Me and an officer and two officers had to carry my nephew down to the corner because the EMS couldn't get past because he was bleeding.
So the police arrived by that time, is that correct?
Yes.
If you know, how long did it take the police to respond from the phone calls from the house?
I don't know.
And just to finish up, you witnessed no arguments between the people in the Durango and Mr. Kirkley?
No.
Do you have any other questions?
Nothing further from you.
Can you redirect? Just briefly, if I may, Your Honor.
This scene across the street at that house, do you know how many people live there?
At Mr. Curtis' house,
Yes, ma'am.
I've only ever seen him. coming up.
Okay. Thank you. Nothing further, Judge.
Ma'am, you indicated that a person that was in close proximity to you was shot. Who was that person?
My nephew Jaden,
And Jaden was shot. Were you next to him when he was shot?
we were standing in the front door.
Standing in the front door.
Yes.
Explain to me how you were standing. Were you standing side by side, one in front of the other, or how?
No, so I was just standing there, like, I couldn't move. So he had came back from the back after the first round of shots rang out, he ran in the back. I was still standing there, he came back from the back and pushed me down.
Okay. And when he pushed you down, is that when he got shot?
Yes.
Okay. Questions based on my question. Okay. Thank you, ma'am.
Thank you.
This time we call Teresa McBride.
Please give your name and spelling for the young lady seated. Please raise your right hand. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. Please have a seat there. Speak into that microphone, let it be to your left. Thank you, you're ready.
Thank you, Your Honor. Good morning, Ms. McBride. Could you state your name for the record, please? Thank you. And I'm going to draw your attention back to July 31st, 2022, ma'am, in the early hours. Where were you that early morning?
Okay, I can't hear you, man. Please speak into the microphone.
I can't remember the street.
It's okay. Who lives over in that area? Why were you in that area that morning?
We was just having a little gathering in our house.
Yeah. Do you recall who all was there at that time?
Myself, Sophia, her nephew, Daniel, friends and family.
And during those early hours, did something happen that brings you into court today?
Yes, so I remember us being outside and then hearing shooting. I thought somebody was just shooting in the air. And I had went to go to get my sister out of the house because, she was with me and I just wanted to take her home, get her out the area. And she actually met me at the door. I told her to go to the van.
So Ms. McBride, you're saying a lot, so I'm
Oh,
gonna bring it up, okay? So you heard gunshots. About how many gunshots did you hear?
Maybe like 5 or 6.
Okay, and then you said you went to go get your sister, is that correct? Where was she?
She was in the house, in Sophia's house.
And what was your sister's name?
Tanisha Farm.
After you went to go look for your sister, what's the next thing that happens?
She actually met me at the door, and I told her to go to my truck and we was gonna go home.
Where was your truck parked?
It was right next door to Sophia's house.
What kind of truck were you driving?
It was it was a blue truck, but the police didn't confiscate or anything. I ended up driving myself to the hospital.
No problem. So you say it's a blue truck. How many doors on it?
4 doors.
When you say truck, do you mean flatbed or like an SUV?
Actually, it wasn't my truck. I was driving my dealership.
Okay. So you asked her to go to your truck. What's the next thing that occurs?
I went in the house and, as soon as I grabbed my purse and my keys, I started hearing, gunshots again. And I got shot in my face.
So,
but it wasn't with an actual bullet, it was like, bullet fragments. I was in a brick house, the bullet went through the house.
So when the gunshots first start going off, where were you standing at that?
I was in the living room.
Okay. And Miss
Or the
Sophia,
dining room.
and that's within Sophia's house?
Mhm.
Is that a yes?
Yes,
Okay. Did you see any firearms?
I did not.
At any point that morning, did you see firearms?
I did not.
Are you sure about that, Ms. McBride?
Did I see any firearms?
Yes, any guns?
I have my gun, but that's right.
No, I appreciate that, Ms. McBride, but did you see any firearms being discharged, shot?
So when the shooting first started, I seen him standing, in the middle of the sidewalk shooting, but I'm not for sure what kind of gun it was.
That's okay. So you said, so you saw someone standing in the middle of the sidewalk. What side of the street was that on?
He was on my left side.
Okay. Is that on the same side of the street as,
Across, right across the street from the house.
so it's across the street from, Sophia's house? Is that a yes?
Yes.
Okay. Could you tell anything about the gun? What color or anything?
I'm not for sure, it was really dark.
Okay. Could you describe, the person that you saw firing this gun?
Like I said, it was really dark, I just see like, a man standing there.
Okay. And then when you got hit, where were you standing at that point?
I was in the dining room inside of Sophia house.
And where on your body were you
In my face, in my, the bullet fragment knocked out two of my teeth. And then I had, bullet fragments hit me up all on my, left side.
Okay. After you sustained those injuries, did you seek medical attention?
Yes, I drove myself to the hospital.
I should back up. During the point where you're back inside the house and you hear more gunshots, do you know how many gunshots you heard at that time?
It was a lot, I'd say maybe like 8 or 9. They kept coming, we all were in the basement.
You indicated that you drove yourself to the hospital. How long were you at the hospital?
I stayed overnight.
And then I just want to go back to your vehicle, and then I'm almost done, Ms. McBride. I apologize.
Okay.
So you said it was a blue truck, but you weren't sure the kind. Is that fair?
Sure, the Equinox? I believe.
Well, Ms. McBride, you remember talking to the police about this incident?
Yes.
Okay. Did you give them a written statement?
I don't think it was written, I think it was just verbal statement.
Did they give you anything to sign when you talked to them about it?
I'm not sure.
Well, if I showed you a statement from you, would that help refresh your memory?
Yes.
Show Mr. Schlaf the first 2 pages of the written statement. Okay. Can I approach her? Okay. Ms. McBride, I'm going to give you these 2 sheets, and I'm going to ask you to look over those 2 sheets of paper, particularly the bottom of that second page. I just ask that you read that to yourself and then look up to me when you've had a chance, okay?
Mm-hmm. Yes.
That is, okay, thank you. I have a fresh memory.
Yes,
Just to confirm, was that your statement?
yes.
What kind of truck were you driving?
Equinox. Blue truck, blue one.
Thank you. Thank you. Ms. McBride, Your Honor, I have no further questions at this time.
Cross-examination.
Please.
Good afternoon. And Ms. McBride, I believe you testified that it was really dark outside, is that correct?
Yes.
And what time would you be saying? When it was really dark at the time of the shooting?
Yes.
And did that prevent you from fully seeing what was going on at that time?
I just couldn't see like the person whose face I was shooting at that particular time.
I'm sorry.
I mean, I was at the corner, so it's really not really much that I could see. It was dark outside.
You say you couldn't see the shooter, is that correct?
I mean, I could see the shooter shooting.
But couldn't give us any other identification?
No.
Okay. And what time did you arrive that night? If you can recall.
Maybe like around 10 or 11.
All right. And you were with somebody else?
My sister.
Okay. And what was the occasion of this? Yes, yeah.
It was a tattoo party.
A tattoo party? And it being a party, were there any alcoholic beverages or other intoxicants?
No, it was just a little small little gathering. I really had just got there right before the shooting, but we were just playing cards.
All right. And were there how many people would you say were inside of that house?
Maybe around like 9 or 10.
Were there any other people outside that you know of?
I mean, we had just came outside prior to the shooting with bang rap with it.
So you're saying once you came out, once the shooting began, is that when you left? Went outside? Are you saying when the shooting began, after the shooting, is that when you left and went outside?
After the shooting?
Yes.
Yes, I left from the hospital.
Okay. And were there any other people outside at that time?
I wasn't even paying attention. I know my sister had ran down the street and she was with another girl and I picked her up from down the street.
Okay.
I wasn't really looking for anyone.
All right, thank you.
Briefly, if I may, Your Honor.
Yes.
Ms. McBride, you indicated when this started that you were at the corner, is that correct?
Yes.
When you're at the corner and looking down the street, what side of the street is Sophia's house?
It's on my right side.
Okay, about how many houses between the corner where you're standing, Sophia's house are there?
Maybe 4 houses. You know, it was like a alley.
There's also an alley in there too, you said? Is that a yes?
Yes.
And then, so when you're looking down the street, where is the shooter standing again?
On the left side.
On the left side, okay.
In front of the street from Sophia.
Thank you. Your Honor, I have no further questions.
I think were any shots fired in your direction
While I was outside,
at any time?
while I was in the house, yes.
You were in the house, shots were fired in your direction?
Yes, that's what I was.
How do you know shots were fired in your direction?
That's why I was shot in my face.
You were shot?
Yes.
And where were you shot in?
In my face, and in my arm, and my leg. On my leg.
Is that 2 separate shots?
It was really, bullet fragments. I guess when the bullet hit the grip, it, shattered. So I got hit with a bullet fragment.
Okay. Questions based on my questions?
Okay.
Thank you, and we start.
Thank you.
Your Honor, this time people call Officer Kegler.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Thank you. Please have a seat for the response. The microphone's with them. May be ready.
Thank you, Your Honor. Good morning, Officer Kegler. Could you just state your name again for the record, please?
Good morning, my name is Officer Daisha Kegler,
Thank you. How long have you been a police officer, Officer Kegler?
4 years.
Okay, where are you currently assigned to?
Detroit Police Department 8 Precinct Patrol.
Where were you assigned back on July 31st, 2022?
Detroit Police Department 8 Precinct Patrol.
Thank you, Officer Kegler. I want to draw your attention to that morning. Did you receive a run as it pertains to this case?
Yes.
Where did that run take you
It was an accident off of Greenfield and post line in this area.
to? Did you go to that location?
Yes.
Were you partnered with anyone that day?
Yes.
Who was that?
Officer Teemer.
About what time did you go to that location?
I believe it was maybe 2 o'clock in the morning.
When you arrived on the scene, did you make any observations?
Yes, I did.
What was that?
There was a Dodge Durango that was crashed inside of a occupied apartment complex.
What color was this Dodge Durango?
It was black.
Did you observe anything on the exterior of the Dodge Durango?
Yes, there was a bullet hole in the vehicle.
And what side of the vehicle were those?
Paint hole, passenger side.
How many people were in the vehicle?
There were 2 people.
Did you notice any injuries on these individuals?
Yes, they both suffered from gunshot wounds.
After you responded to the scene, what did you do at the scene?
Try to render aid, have talked to the victims, make sure EMS got there so they could be transported to the hospital, secure the scene.
Did you, as part of that work, collect identification or anything like that?
Yes, we did get identification.
Who were the 2 individuals?
Mr. Kill and I don't have my report for Mel's name.
You said it's not in your report for the.
It's in the report, I don't have my report with me.
Oh, sorry. Got it, not a problem. Would looking at a copy of that report refresh your memory if I showed it to you?
Yes.
All right, may I approach? I'm approaching with a copy of that same report. Officer Kegler, you've done this before, but take a moment, just refresh yourself and look at me when you're done, please. Did I refresh your memory, Officer Kegler?
Yes.
Who was the other individual?
Mr. Willis.
Thank you. Thank you, Your Honor. Nothing further for Officer Kegler. Thank you, Officer Kegler.
No questions, Judge. Thank you, Officer. You may step down.
Thank you.
All right, the second people call Officer Rizzo.
Officer Rizzo.
Judge, just so you know, after this, I plan on calling Detective Terrell.
Step forward, sir. Please give your name and spelling to the court reporter. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat. With response next to me. Thank you.
Thank you, Your Honor. Good morning, or excuse me, good afternoon, Officer Rizzo. Could you just please state your name again for the record, please, sir?
Officer Rizzo,
And where are you currently assigned, sir?
4th Precinct.
Where were you assigned back on July 31st, 2022?
I was assigned to the 4th Precinct.
And how long have you been a police officer with the Detroit Police?
September 2021.
That's when you started. I want to draw your attention back to the early morning hours of July 31st, 2022. Did you receive a run as it pertains to this case, sir?
Yeah, I was an assistant in this one.
Okay, so where, I apologize, but
Yeah, I was an assistant.
what time did you receive that run, sir? Refresh your memory, sir? Would that refresh your memory?
To look down the report?
Yes, sir.
Yes, sir.
Just gotta ask the question, sir.
Roughly the 3:01.
When you responded to that run that day, sir, were you partnered with anyone?
Yes.
Who was that, sir?
I was Officer Keys.
And where was your run going to?
We're going to. I think he should be.
Please report to the first recollection. Members request returning over and testify.
Yes, sir. Yeah.
Would that refresh your memory, sir?
Yes, sir.
Do you have a copy of that report in your hand, sir?
I use.
Please take a look.
We're responding to the address of 11637 William Street.
Thank you, sir. When you arrived on the scene at that location, what did you do?
Stood by for waiting to see if it was going to be barricaded. At that address, across the street at 11634. Then entry to that house.
Did you do anything while you were making entry into the 11634 address?
Just making sure everybody's okay there.
Okay. After going to that side of the street, did you go back to the 11637 address?
I did.
What did you do there?
We knocked and bounced.
When you say we, how many of you are there at this point?
Myself, my partner, my supervisor, maybe 4 more other officers.
Okay, after knocking and announcing, what's next?
The defendant came out. And he was detained.
After detaining that individual, what did you do next?
They brought them over to primary unit's car and searched them, and that was it.
Okay. Did you do anything else while on scene?
After that, we made the regular protective suite to the house. Multiple weapons on our house.
Okay. Was anyone else present within the house?
No.
Thank you, Officer Rizzo. Your Honor, I have no further questions.
Cross-examine?
Yes, Judge. Afternoon. I believe that you testified that you made your way to 11637 Fourth, is that correct? Yes. And what was your purpose for going there?
Assisting the primary units.
And by assisting the primary units, what do you mean?
They're asking for backup. We see.
Okay. And then at some point you went over to the Toilet Express where you believed the shooter might be?
Well, the first address I went to, I know it was a vision. So that was where the street.
All right, did you eventually make your way to the house across the street?
Yeah.
And with how many officers?
At 11/6/37, we went back to the house.
I didn't mean to cut you off. How many officers went with you across the street?
We came from July, it was myself, my partner, supervisor, maybe 4 or 5 other officers.
Is the house surrounded?
We-
No. Did any of the officers take up positions around the house?
Yeah, we all checked around the house.
Okay. Who went to the door?
I don't remember what officer was at the front door.
Did you go to the door?
I went to the side of it.
Okay. Did the person inside the house come outside the side door or the front door?
It was the side door.
So when you came out of the house, he was arrested at the time, is that correct?
It was one place in the house.
And at that point, did you look inside the house? Were you able to see from where you were into the house?
No.
Okay. Whose decision was it to enter the house after Mr. Kirby was arrested?
One second.
Was it your decision?
No.
So how many officers went into the house?
The same amount of officers that were there.
Okay. And at that point, there was no search warrant to your knowledge, is that correct? All right, now you go.
I'm sorry, was that it?
Is there any other words?
Okay. Sir, that person that surrendered themselves, do you see that person in the courtroom today?
Yes, sir.
Would you point to him and tell us what he's wearing?
He's wearing, can't tell if that's green and blue.
Did you point to him?
Yes.
All right. Record should reflect the witness has identified defendant, Mr. Incredible Jr. Any questions based on my question? Thank you, sir. Yes.
You're gonna just have people call Detective Terrell.
Please raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. and see if it responds. Maybe you're ready.
Thank you, Your Honor. Good afternoon, Detective Terrell. Could you just state your name again for the record, please?
Detective Trooper Beatrice Terrell.
Thank you. And I want to draw your attention back to the July 31st, 2022 date. Detective Terrell, did you make the scene in this case?
Eventually, yes, I did.
When you made the scene, what was your duties at that point?
At that point, we started to actually search both homes, the victim's home and the suspect's home.
Okay. When you searched the suspect's home, what address was that?
I do not recall the address.
Would that be in your report if I showed it to you?
Yes.
Can I may approach? You may. Try to copy of the search report, just for the record. Detective Terrell, I just ask that you take a look at that for me, please. Does that refresh your memory, Detective Terrell?
Yes.
And which house, or what was the address of the suspect's home?
11637 Coyle Street.
Thank you. When you searched that house, were any recoveries there?
There was just several firearms, ammunition.
I want to ask you about something we tried to raise. I don't know if it's on that report, but Detective Terrell, what was item number 25 that was recovered? Is that on that report?
Can't look.
Yes, please. Well, first, do you know what item 25 was? Let me do it properly. Off the top of your head.
I know it was a long gun, a firearm.
Okay. And where was that specific firearm recovered from?
I remember. I know it was recovered in 11637, the residence of that address.
And then I'll take that report back from you. Thank you. As part of your work on the scene that morning, Detective Terrell, were any shell casings recovered?
Yes, there were a lot of shell cases recovered.
Where were those located at?
Some were located in the grass of 11637. I believe somewhere on the sidewalk in front of 11637. And then there were several shell casings in front of 11634 Coyle Street, which is the house directly across the street from 11637.
When you said that you searched two locations, was that the other location?
Correct.
The shell casings recovered in front of the 11637 location. Do you recall what caliber those were?
I believe they were 223s, but I'm not sure. I know they were rifle rounds.
Apart from the firearms that were collected from within 11637, were any other firearms collected by the police that morning?
Yes, out of 11634. It was a handgun.
Do you recall from where inside 11634 that was recovered?
The dining room table.
Thank you, Detective Terrell. I don't believe I have any further questions.
Good afternoon.
Good afternoon.
I believe you testified that you eventually made the scene, is that correct?
Correct.
And when would eventually be?
It was, I made the hospital first and
Okay.
conducted several interviews. By the time I got to the scene, it was daylight.
All right, so daylight, early morning, daylight, afternoon,
Early morning.
okay? And was the scene still being held at that time?
Yes.
By the time you made it back to the scene, had you or any other officers obtained the search warrant?
Other officers, yes.
All right, and did you have knowledge of that search warrant?
Yes.
And you know when time, strange.
I think that. You refer that. Thank you, Mr.
Okay, this time I have no further witnesses.
No witnesses from the defense.
So a few things, Judge, but last time we were here, just to refresh, I took your copies of the exhibits that I published. Would you like those back for these purposes or?
I'm good.
Okay. So a few things, mostly, Judge, I would argue for bind over as charged with the exception of, I want to make sure I get the right ones. Mr. Stubbs, which is count 5, and the associated count, felony firearm count, which would be count 12, due to the fact that he did not avail himself of his court appearance today, Judge. Otherwise, Judge, I think it's clear based on the testimony of all these assault with intent to murder.
It's count 5 and count 14. Talking about Stubbs.
Yes, Judge, I might have. Yep. I didn't realize it specifically said it on there. I apologize. That's correct. So based on the testimony, both of Jonathan Griffin, Ms. McBride, Ms. Robinson, Jalen Steen, and Ms. Owens, all of them were hit either by bullets or bullet fragments during the course of the shooting spree. Ms. Sophia Steen specifically identifies her neighbor, though she didn't know his name at the time, as the shooter that resided just across the street from her, as well as the fact that count 9, Jalen Steen indicated that he was standing inside the doorway of the house when he was hit by that bullet, which is incidentally, Judge, his aunt Sophia Steen was standing right there, so I think there's a very good argument for an assault with intent to murder count for Ms. Sophia Steen based on where she's standing at the time of this rampage. I
thought she was actually charged with complaint.
She was not, Judge. I don't know why that was part of that process, but so I would move to actually add a count of assault with intent to murder for Sophia Steen with a felony firearm account attached to it. But there also has to be a correction, Judge, of the location. It should be 11634 Boyle, not 11364. But in any event, Judge, the evidence shows that this was a deliberate act. In People's Exhibit 3, which was the lab report that I published to you last time, Judge, there are numerous shell casings of the rifle caliber, as Detective Terrell testified to, that were collected from outside the 11637 location, which matched to item number 25, which is that rifle that's collected from inside the house. It was testified to by Officer Rizzo that the only person that was in the home at the time that he arrived on scene and the police knocked was the defendant. I think that based on all the evidence presented by the people during the course of these 2 days, that there's more than sufficient evidence for a probable cause standard to meet the elements of the crime's charge. It was testified that this occurred in the city of Detroit, County of Wayne, back on July 31st, 2022, and I move to bind over as charged in the counts stated, minus the Daniel Stubbs counts, but with the addition of those 2 counts for Sophia Steen.
Why don't you just amend count
5 to say Sophia Steen?
Yes.
That would be approved,
Count
Judge.
5 and 14, Sophia Steen.
Yes, thank you, Judge.
Stop.
Okay. Thank you. In response, Your Honor.
Can you get to the podium, so.
I'm sorry. In response, Your Honor, I always thought that I was loud enough for anybody to hear.
Most of the time you are.
In response, Your Honor, as to the bind over, I would say that some accounts is a question of fact, and others perhaps not. As to Ms. McBride, it's my belief that she was well inside the house when the shots occurred, and she testified that she was hit by fragments. And I think that that would be more covered by the count of count 9, discharge in or at a building causing injury, and not one of the assault types of charges. As for the rest, Your Honor, I believe there was some testimony from the Steens as to their position in the house. And I say similarly, we may not exactly have them at the door itself, but perhaps further in the doorway. And I think the same argument could be made for those two. As to any identification of my client, Your Honor, based on the testimony of was it Ms. McBride as well, who said it was really dark outside, as opposed to Ms. Steen, I would say that there is no good basis to believe that any identification could be made. I believe Ms. Steen could have been making those arguments.
Ms. Steen was pretty equivocal, wasn't she?
Well, I was going to answer that, Judge. I think that her unequivocal statement should still be questioned, Your Honor.
Why wouldn't that be a question of fact to be determined by a trial?
Well, because still,
she says without question it was their client.
As a
and
finder,
she's seen him many times before, and she's seen him on this occasion.
as a finder of fact, even for a preliminary exam, the court still must weigh the credibility of witnesses. And I would say, based on all the circumstances, that the shooter might have been in the direction of this person's house, 637 Coyle, that you could not necessarily make an identification based on those circumstances, Your Honor. Too dark, too far of a distance. That's my argument.
Just briefly, two things. So I think the testimony of Ms. McBride and Ms. Sophia Steen proved two things. That Ms. McBride was standing 4 or 5 houses down with an alley between the shooter and herself when this happened, which accounts for the fact that she couldn't see the face of this individual. What she said it was a man that had done the shooting and that he was standing across the street from Sophia Steen's house. Ms. Steen, on the other hand, was standing in front of her house, either on the porch or on the sidewalk, looking directly across the street where she saw her neighbor coming in and out of that home. But even if we discount what Ms. Steen said, Officer Rizzo said that when he went and they did the protective sweep of the house, the defendant was the only person there. And then that firearm, which is then inside the house, when Detective Terrell and Michigan State Police do their search, also shows to be that this is a gun. So even circumstantially, Judge, there is enough evidence for a probable cause standard.
What about Mr. Swamp's argument about
the wherever we're standing
and the discharge of the firearm and the building?
Well, Judge, certainly charges of adding charges of discharge of a firearm at a building are fine, but when he is pointing the gun and shooting at the house, he knows that people have been coming in and out of the house the entire time. And the testimony was that the Steens were standing in the doorway. It doesn't matter if they're standing 1 foot in the doorway or 10 feet in the doorway. If the gun's pointed at them and they're being shot in the manner that all these shots are happening, that's assault with intent to murder. And it doesn't matter if Ms. McBride is standing at the back of the house, the front of the house.
She's in the line of fire.
She's in the line of fire, and the defendant knows that. Exactly, Judge. No, that's what I'm saying. I said for the other scenes, they could be added charges for discharge at a building. The fact that one's charged as discharge at a building versus assault intent to murder, it doesn't matter. They overlap and they can both coexist, Judge.
So I think we have before us a very straightforward question of fact to be determined by a trial as it relates to the identification of the defendant as being the shooter. I have witnesses who came forth and testified unequivocally that it was in fact the defendant who was firing those shots. They were in a different position of another witness who says that it was very dark outside as opposed to this witness who's looking at the defendant straight on. It says that it is responding officers make it seem he's the only one in the house. Numerous weapons are recovered along with the weapon that was used in this incident. Court is satisfied the people met their burden of probable cause as it relates to all the charges contained in the complaint warrant, including the amended charge, count 5, assault with intent to murder Sophia Steen, and count 14, felony firearm as it relates to Sophia Steen. The court finding those charges were committed in the city of Detroit. The court finding probable cause to believe this defendant committed them. Will bind the defendant over to Wayne County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be July 25th, 2023 at 9:00 a.m. The defendant will be remanded to the custody of the Wayne County Sheriff.
Thank you, sir.
Thank you, Mr. Kirk.
Don't get the amendment information.
Yes, Judge. No changes for yet.
Yeah.
You withdraw.
Thank
Thank you, Your Honor. Have a good rest of your day.
Thank you as well. Thank you, you too.
Judge, can we approach really quick?
Yes.
You need me? No, I'm just gonna. I brought an intern with me today. She hasn't ever been part of an exam. So.
Oh, hello there, intern. Do you have a name besides intern?
Cecilia.
Nice to see you. Nice to meet you.
Nice to meet you.
So you are a law student?
Yes.
Where at?
University of Toledo.
Oh, really? Okay.
Yes.
I spoke there a long time ago.
Oh, really?
Interesting. How do you like the law school?
I very much enjoy law school. I'm actually trying to transfer.
In other words, you're here.
I don't enjoy the starting classes, but I enjoy running law school.
Okay. And what year is this one?
I'm a writer as well, so about a month ago,
Okay.
starting.
Congratulations to you.
Thank you.
You want to do criminal law?
Yes,
It's the most interesting thing around.
it is for sure.
Absolutely. Okay, well, it's a pleasure to meet you.
Nice to meet you. Thank you.
I appreciate
Learn
it.
a lot from these guys. I think everybody who says they enjoy law school. Well, we are down to for lunch until it's the lunch at 1:40.
You have another call at 1:30, Judge?
I'm sorry, I didn't hear you.
You have another call, another docket, 1:30?
Yeah, we're gonna do the next case at 1:40.
Okay, I'll be back at 1:40.
All right.
CR 140.
Okay.
Will be locked.
Thank you, you too. Let me know when I have everybody here. Okay? Yes, sir.
Good afternoon, Your Honor.
Good afternoon, sir. How are you doing?
I'm blessed, Judge. Yourself?
Well,
Good to see you.
I'm sharp.
I'm just trying to be like you, Judge. No. The respondent.
Is that everybody?
Yes, sir.
All right. Welcome, ladies and gentlemen, to the 36th District Court. It's incumbent upon me to impress upon you how important it is for you to behave yourself accordingly. I don't know who's here for who, and quite frankly, I don't care because I'm going to treat all of you the same. If there are any disruptions, just understand that there's plenty of room in the back. I shouldn't even know that any of you are here, meaning I don't want to hear a sound from anybody, okay? As long as that's understood, Mikasa is Sukasa. On case 2357308 for the state of Michigan versus Marcus Deshaun Ruger. Defendant is charged in count 1 reckless driving causing death, count 2 failure to stop at scene of accident when at fault resulting in death. Defendant has an habitual offender third offense notice. Appearances for the record.
Good afternoon, Your Honor. Sarah Benoma on behalf of the people, P84189.
And good afternoon, Your Honor. Respectfully, Chad Paddock, P82492, appearing on behalf of Mr. Marcus Ruger, who stands before the court today. Your name for the record, sir. Nice to meet you.
Marcus Ruger. There's a date and time set for preliminary examination. Are you ready to proceed?
People are ready to proceed, Your Honor.
How many witnesses will be?
3, Your Honor.
Have any preliminary matters? Like,
Yes, Your Honor. 2, the people would ask for a mutual sequestration order with an exception to the officer in charge, Detective Shrivaka Dejara, who stands to my right.
any objections?
No objection to the
Ladies and
lady.
gentlemen out there in YouTube land, if you are a witness or potential witness, in order you to log off at this time. Likewise, ladies and gentlemen in the courtroom, if you are a witness or potential witness, you may testify at some point down the road. I'm asking that you step into the hall. Say anything else?
Yes, Your Honor. Pursuant to MCL 76611BD, people move to omit People's Exhibit 1, which is the post-mortem report. We do have stipulation between the parties for the omittance of People's Exhibit 1 and for identification purposes that the deceased located at the scene of Roosevelt Outlaw is the individual that is in this report for exam purposes only.
So stipulated? Court received that stipulation?
Your Honor, may I publish?
Yes.
Your Honor, may I read the pertinent portions into the record?
Yes, you may.
Your Honor, People's Exhibit 1 is entitled the Post-Mortem Report from the Office of the Wayne County Medical Examiner. It certifies that Dr. Lee Lavati, Assistant Wayne County Medical Examiner, performed a post-mortem examination on the body of Roosevelt Outlaw at the Wayne County Medical Examiner's Office on June 12, 2023, with the ME case number of 23-07365. In the summary and opinion portion of this document, it states, it is my opinion that death was caused by multiple injuries sustained as a pedestrian struck by a motor vehicle. The manner of death is accident, and the report is signed by the Assistant Medical Examiner. With that, Your Honor, people are ready to call their first witness.
Okay.
Your Honor, at this time, people call Officer Anthony Anderson.
Sir, please step forward, give your name and spelling to the court reporter, just to your right. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you, sir. Please have a seat in the witness box right next to me. Maybe begin when you're ready.
Thank you, Your Honor. Can you please restate your name again for the record?
Yes, ma'am, Anthony Anderson.
And where are you currently employed at?
I am at Detroit Police Department at the 9th Precinct,
And for how long have you been employed in that capacity?
2.5 years.
Were you employed in that capacity on June 11th of 2023?
Yes, ma'am.
Did you in fact work on that date?
Yes, ma'am.
Were you by yourself or with a partner?
I was with a partner.
What's your partner's?
Christopher
That LIPA?
LIPA, yes, ma'am.
Okay. Did your duties as an officer get you dispatched to the area of 7 Mile and Hoover?
Yes, ma'am.
Is that in the city of Detroit?
Yes.
County of Wayne?
No.
And what brought you to that location?
So we got a call for an accident on 7 Mile and Hoover, and as we got to the scene, we was approached by a civilian who said that somebody was laying down on the ground and was possibly dead, and that's when we left the scene to go there.
And from the scene to Annex Street, how far away is that?
Maybe 2 blocks.
Okay. When you make that location of Annex Street? Annex Street, what if anything do you observe?
We observed our victim in the middle of the street. We noticed that he had an rental pretty bad. We was unable to move him due to his condition. We called it. Engine 60 actually made the scene, but unfortunately they called it 0411.
Thank you. No further questions.
Cross-examine.
Good afternoon, officer.
How you doing, sir?
I'm good, yourself?
Good.
You talked to any witnesses while you were at the scene?
Yes, I had. Only witness that we talked to was across the street. We had Xfinity live video footage.
Okay.
And that's the only witness that I talked to. Everybody else that was on the block, across the street from that house, just came outside after they seen a license sign.
Did you see that video?
Yes.
You recall it?
Yes, I did.
What did you recall in the video?
So in the video,
probably it's the best evidence. Best evidence from the video itself.
Withdrawn. When you first arrived at 7 Mile and Hoover, you said there was an accident scene?
yes, I think 3 cars were involved.
Were the 3 cars still there?
So 3 cars were involved in that accident. Later on, after we had went to Anna, we had crime intel. I actually called crime intel to see if they noticed any vehicles that had left the accident scene. The first time he called me, said, no one left. We looked back, that's maybe 30 minutes, 10, 15 minutes later to see if there was someone that left. That's when we got the Kia that had left the accident scene, or rear ended somebody. They started making their way east on 7 Mile and they made north on that night.
And that's all you have is that the vehicle, that particular vehicle left the scene.
Yeah, that vehicle was shown on 7 Mile and Wilbur from our primary tail, and also the same vehicle from the, and address that I got from my witness.
Were there any other vehicles traveling behind or near that vehicle at the same exact time?
Only vehicle I seen was a white Kia. I didn't look any further into the video.
Would looking at your report help refresh your memory?
Yeah.
And do you have your report with you, officer?
Yes.
You can go ahead and refresh your memory.
Okay. Is he refreshing his memory as to?
As to whether he reported another vehicle
Based
near,
on what you viewed on the video?
yes, Your Honor. Well, actually, it would be based on his statements from any witnesses he spoke to as well. If the police officer put something in his report, I believe that the police officer can testify as to what he placed in his report.
Except for he's giving
So in my report, I
hearsay
did,
statements. You see, hearsay statements. That saw something.
I'll rephrase the question to the court. Do you recall reporting anything of another vehicle at that same time, same day?
Your Honor, and I'm just gonna object to ambiguous, because now we're talking about two different scenes, the original car accident or the scene on the net. So I just asked for that.
Again, unless the officer was there, unless he was present and made these observations himself, we think that the information he received would be by way of hearsay.
Withdrawn, Your Honor. I have no further questions.
Can you redirect?
No, Your Honor.
Thank you, sir. You may step down.
thank you, sir.
Your Honor, may I call my next witness?
Please.
Your Honor, this time people call Sergeant Johanna Todd. Your Honor, may I share my screen?
All right, you're close.
Thank you.
Please give your name and spelling to the court report. Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat. Please, 5 minutes. Maybe begin when you're ready.
Thank you. Can you please restate your name again for the record?
Johanna Todd,
And where are you currently employed at?
Detroit Police Department,
And what is your title?
Sergeant,
And how long have you been employed for the Detroit Police?
14 years.
Did you make this scene on June 11th of 2023 of a net in Lappin in Detroit?
Yes,
When you made that scene, did you observe a deceased individual in the road?
yes.
And did you observe anything else surrounding that individual?
There were broken vehicle parts on the ground.
Did you review green light footage from 7 Mile and Hoover from June 11th of 2023?
Yes,
And Your Honor, I would move to omit People's Exhibit 2 by way of stipulation with defense counsel.
So stipulated.
And Your Honor, may I publish?
Yes.
On this screen, are there 5 videos from Hoover and 7 Mile?
yes.
I'm going to expand camera 1. We're at 34700. This intersection of Hoover and 7 Mile, how many car accidents took place on the night in question at this location, at this intersection?
2,
In this video, do we see the first car accident takes place? Do we see the vehicles that are involved in this video?
Yes.
Can you kind of tell me where they're located at in the video?
There's a vehicle that are closest to the corner, closest to the street sign.
So if I'm circling with my mouse, is this the area that these vehicles are located at? And there's a delay, so let's sure.
Yes.
Okay. Now, has the second accident taken place yet?
Not yet.
Do we see any of the vehicles involved in that accident on the screen?
There's the red car and then there's a white Kia Sorento. The white Kia is not visible yet.
When you say there's a red car, I see a red car, there's one pulling out of the gas station and one kind of over in the street. Which one
The
is it?
second one.
The vehicle in the street?
Yes.
Okay. Your Honor, people are fleeing People's Exhibit 2 from 347 to 347-12. And I would draw the court's attention to the red vehicle just identified by witness. I'm stopping the video at 347:17. I'm gonna play the video one more time, 347 starting. And then stopping at 347:12. Again, stopping that video at 347:12. I'm now expanding camera 3, playing this portion from 347:05 to 347:14. Again, playing the video 347:05. I'll go 06 to 347:14. Starting that video at 347:14. Expanding camera 5. Playing that video from 347:03 to 347:25. Starting the video at 347:25. Sergeant Todd, the vehicle, does it make a right or a left turn in the video?
It makes a left turn.
And what street is that vehicle turning onto?
And
Did you next review any residential home video of this incident?
yes.
Your Honor, people had moved to admit People's Exhibit 3 by way of stipulation with defense counsel.
So stipulated.
Is this at 19326 Anat Street in Detroit?
Yes.
Just one moment, I'll have them screen. People are playing People's Exhibit 3 for 24 seconds. People are going to play the video again. It's kind of quick for 24 seconds, and that'll be it for the video. People are stopping the video at 24 seconds. Sergeant Todd, with this information from the video, what, if anything, did you do next?
I did a search through our license plate reader system through Flock.
Did you receive a picture from that?
Yes.
Your Honor, may I approach?
You know,
Any people's proposed exhibit 4? Does this photo look familiar?
Yes.
How does this photo look familiar?
This is the license plate read that I had received from Flock.
And does that fairly and accurately depict the photo that you received on the day?
Yes.
Okay. Your Honor, people move to publish people's exhibit 4.
any objection?
No objection.
Admitted?
Your Honor, may I publish?
Yes.
And what, if any, information did you obtain from this photo?
So this photo contains the time, the date, the geographic location, and the license plate number of the vehicle that passes by.
What is the time and date listed on this photo?
So this is June 11th at 3:49 and 55 seconds a.m.
The video that we watched, the green light video, of the car collision, what time is that?
3:47 a.m.
Okay, and then the residential video, what time is that video?
I don't know exactly what time that was.
That's okay. From this photo, the vehicle, how far away is it from the scene?
3 blocks.
3 blocks from the scene. What's significant about this photo that drew your attention to it?
So what drew my attention to it is it is a white Kia Sorento where its headlights indicate pretty long.
Okay. And with this information, what, if anything, did you do next in your investigation?
So I did an additional search with that license plate associated with the vehicle through additional Flock and Genentech license plate systems.
Did you get hits from that?
I did.
Your Honor, may I approach?
You know,
Any people's proposed exhibit 5A, B, and C. Can you look through those photos? Let me know, do those look familiar?
Yes.
Do they fairly accurately depict the photos that you received when you entered that license plate in exhibit 4?
Yes.
Your Honor, people would move to omit people's exhibit 5A, 5B, and 5C.
any objection?
No objection.
Your Honor, may I publish?
Okay.
Starting with people's exhibit 5A, what's the date on this photo?
This is June 10th at 3:59 p.m.
And where is this photo taken at? What's the location?
7 miles of Chalmers eastbound on 7 miles.
And was this photo, the date, was that before or after the accident that we observed on the green light?
That was before the accident.
In this photo, does there appear any damage on the vehicle?
I do not see any.
Turning to people's exhibit 5B, what's the date on this photo?
June 10th, 2023 at 8:51 p.m.
And what location is this at?
This is 7 miles at Hoover, northbound on Hoover.
Is this before or after the accident?
This is before.
Does there appear to be any damage on the vehicle?
I do not see any.
Turning to people's exhibit 5C, what is the date on this photo?
This is June 11th at 4:16 p.m.
Is this before or after the accident?
After.
After. Does there appear to be damage on the vehicle?
The front end appears to be damaged.
With this information, what, if anything, did you do next in your investigation?
I put the license plate into lien and any NCIC as a wanted vehicle.
Did you receive information once you listed that vehicle as wanted?
I did. I received information from Springboro, Ohio Police Department.
Did they have custody of that vehicle?
They did.
Did they have custody of the driver?
They did.
Okay. Do you, what, if anything, did you do next?
I drove to Ohio. I drove to Springboro, Ohio Police Department.
Did you speak to the driver of that vehicle?
Yes.
Do you see that individual report today? I do. Can you please point to that individual and state something there?
He's seated at the defense table when directing.
Your Honor, may the record reflect identification of the defendant?
So moved.
Was anyone else with you when you spoke to the defendant?
Now Sergeant Paul Warner.
Thank you. No further questions here.
Cross-examine.
Action, Sergeant.
Good afternoon.
Sergeant, you stated that you looked at that video that was approximately how far away from the accident?
Are you talking about the Settlement Mountain River or the video on Anna?
The video on Anna.
That's about 3 blocks north and half a block to the east.
And you fully reviewed that video yourself?
I'm sorry, which video?
The one on Anna, I'm sorry, from now on, I'll call it the Anna video.
Yeah.
The Anna video, you fully reviewed that video, is that correct?
Yes,
And what did you say you saw in that video?
there's 2 vehicles going northbound.
All right, stop right there. 2 vehicles.
Yes.
Okay, go ahead.
Again, the video speaks for itself.
I understand, Your Honor. It does.
You're asking her what she saw in the video.
I will get to that. Go ahead. Sergeant,
Yes.
No, it's not. Go ahead, and she's explaining what she saw in the video. Now let's investigate.
were you able to, I'll withdraw, Your Honor. Were you able to ascertain what the other vehicle was?
I have not identified the other.
So it's unidentified.
That's correct.
And when you said you drove down to, is it Springfield, I believe? Ohio?
Springboro.
Springboro, Ohio. Thank you, I appreciate it. And did you meet with the defendant at that time?
Yes.
Okay. And at the time that you met with the defendant, did you read the defendant's constitutional rights?
Sergeant Warner presented him with the constitutional rights of rights. The defendant read it out loud himself. He signed it.
What time of the day was that when you met with the defendant?
It was probably about 1 a.m. I don't remember exact time.
About 1 a.m.
It was late.
when you arrived?
Yes.
Somewhere in that time period. And did they bring the defendant out to you? Did you go to see him in his cell or wherever they were holding him?
He was in a cell.
He was in his cell. I don't have any further questions for this witness.
Do you regret?
No, Your Honor.
Thank you.
Thank you.
Your Honor, may I comment as witness?
Please.
Your Honor, people call Sergeant Paul Warner.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you, sir. That's it. Thank you, Amy. You're ready.
Thank you. Can you please restate your name again for the record?
Paul Warner.
Where are you currently employed at?
I'm the Detroit Police Department,
For how long?
27 years.
And what is your title?
I'm a sergeant.
And did you have the opportunity to speak to the defendant in this case?
I did.
Did you see that individual in court today?
Yes, Mr. Rooker is sitting at the table to your left, my right.
Your Honor, may the record reflect identification of the defendant?
So noted.
And was anyone else present when you spoke to the defendant?
Yes,
Who was that?
Sergeant Johanna Todd.
Did you advise the defendant of his rights?
It provided him his constitutional rights and he read them.
Your Honor, may I approach? Handing you People's Proposed Exhibit 6. Does this document look familiar?
Yes,
How does this document look familiar?
this is the document I provided. My name is up on the witness, Johanna Todd. Rooker's name on it.
Does this document fairly and accurately depict the document you used to Give the defendant his rights.
It's a copy with, People's Exhibit 6 on the bottom right corner.
Your Honor, people would move to omit People's Exhibit 6.
Any objection?
No objection, Your Honor.
Your Honor, may I publish?
You may.
Did the defendant read his rights out loud?
Yes,
Did he initial after every right?
he did.
Did the defendant appear to understand your questions regarding his rights?
Yes,
Did he appear, was his speech coherent?
yes,
Did he appear intoxicated or on alcohol or drugs?
not to me, no.
To the best of your knowledge, was the defendant's statements freely and voluntarily given?
Yes,
Your Honor, at this time, people would tender the witness to defense for voluntariness.
Board hears the voluntariness.
Yes, Your Honor. We're gonna stipulate, Your Honor.
All right, the court makes the finding that the statement is normally voluntary, then it may proceed.
Thank you. Did the defendant make a statement regarding the car accident in 7 Mile Hoover on June 11th, 2023?
yes.
What, if anything, did he say?
The vehicle, cut him off and he struck a red car.
Did he state that he stayed at the scene?
He didn't state that.
Okay. What, if anything, did he say regarding after the accident? Where did he go?
He made a left turn off of 7 Mile.
Okay.
And he did not know what street that was.
Did he make a statement regarding once he turns down the street? Regarding anything that happened on that street?
I had asked him if he knew anything about that. He did not have knowledge that he struck anything on that road.
Okay. The defendant's vehicle, did you investigate the defendant's vehicle? Were you able to look at the defendant's vehicle?
I did.
Your Honor, may I approach?
Okay.
Any people propose exhibits 7A through E? You want to flip through those photos? Do those photos look familiar?
Yes.
How do they look familiar?
These are photos I took while I was at Springboro.
Okay. Do you know about what date that those photos were taken on?
It would have been on the early morning of the 12th.
June 12th, 2023?
Yes.
Do those photos fairly and accurately depict your observations of the vehicle that you took photos of?
Yes.
Your Honor, people would move to amend People's Exhibits 7A through E.
No objection.
Admitted?
Your Honor, may I publish?
Yes.
No further questions.
Cross-examine?
Good afternoon, Sergeant.
Good.
Sergeant Warner, my apologies. I'm sorry, I was looking at 2 different reports. So you arrived somewhere down in Ohio to speak to the defendant. It appears to be on or about, according to this constitutional statement, just shy of 2 a.m.
I know I left here on the 11th and I arrived there on the 12th early in the morning.
Early in the morning. When you approached the defendant, was he in a cell or sitting outside at a table or chained something?
He was at a table, not chained, that blanket over him in a room off to, I don't know if it was an interrogation room or it was a room for Springboro Police Department.
Was he sleeping when you arrived?
I don't know if he was sleeping when I arrived.
When you saw him, I'm sorry, I expect that.
He spoke to me, so I'm going to go with he was not sleeping at that moment.
And then you said you took pictures of the vehicle while you were in Ohio, is that correct?
I did.
Has Detroit police taken custody of this vehicle, or is it still?
We do have possession of it.
You do have possession of the vehicle.
Yes.
To your knowledge, Sergeant, do you know if there's been any DNA tests, prints, or anything taken off the vehicle?
I know that the vehicle is currently within Michigan State Police.
So it's in possession of MSP.
Yes,
You testified that after you spoke to the defendant told you that he was involved, you're saying, in a auto accident, and it doesn't recall anything else. Yeah, correct? Is that what he told you?
he did describe striking out a red car.
Yeah.
And did not remember striking anything on the side street.
Just a moment, Aaron. So you were part of the investigation, is that correct, Sergeant?
Yes.
Were you at the scene at the time of the accident? Did you arrive at the scene or did you come at a later time?
I was recalled after primary units arrived.
Okay. And you reviewed green light video, is that correct?
I did.
And when you reviewed that video, strike me again, let me rephrase. Did you speak to any witnesses?
I had a verbal conversation with a homeowner.
Okay. Do you recall that conversation?
Parts of it, yes.
Do you recall if they ID'd the defendant?
No, that wasn't part of the conversation.
Did you speak to any witnesses that ID'd the defendant?
No.
Were you able to ID the defendant from any video that you see?
No.
No further questions.
No, Your Honor.
Thank you, sir. You may start.
Thank you.
No further witnesses for the people.
Any witnesses for the defendant?
None for the defense, Judge.
Your Honor, the court first heard testimony from Officer Anderson, who made to the scene at 7 Hoover for a car accident. He obtained information from a civilian who stated that there was a body laying in the middle of the street. We know that's Roosevelt. He was laying in the street on a net street. Sergeant Todd then makes that scene. She observes vehicle parts scattered about the defendant's or the victim's body, surrounding. We see green light footage, Kia Sorento, a white Kia Sorento, back end of red Malibu, leave that location and make a left on the next. We then hear from the residential home video in 7 seconds. We hear the impact the vehicle makes when it hits the victim. We see a light that flies up in the air, possibly a cell phone. We hear the victim state out loud. We then see the vehicle swerve to the right, wheel his tires, and then accelerate his vehicle fast down the side street. Sergeant Todd then enters, looks around and plot, and notices there's a vehicle, this is People's Exhibit 4, that has no lights on. She further looks into that, pulls more license plates. She finds photos of this vehicle before and after the accident. And she sees that after the accident, this vehicle now has damage to the front end. Sergeant Warner then speaks to the defendant, who admits to being in the accident prior to the deceased being hit, but that he didn't know that he hit something on a next. Your Honor, the people's position that it's a question of fact as to whether he knew. But in the evidence report, it states that the victim is 5'8", weighs 193 pounds. So the defendant struck this individual head on. We hear it in the video. We hear the victim. We see him swerve. Your Honor, he knew. But ultimately, that's for the jury to decide. So if you are respectfully requesting that I go around all charges.
Move it on.
What did we hear? We hear officers conducting an investigation on a vehicle. We have no eyewitnesses. Nobody IDs the defendant driving that vehicle on that set of date and time.
Doesn't your client resolve that though by saying or admitting that you got into an accident?
Your Honor, what we also see is a video, but what appears to be a dark video. Does not appear to be who was struck.
But your client tells us that he got involved in an accident.
But there was 2 cars on that street as well. Which vehicle? We do have a deceased, which is extremely unfortunate, and may God rest his soul. But we have 2 vehicles driving down that street within less than a second of each other. We don't know what he hit or who hit. Whoever was driving that vehicle. What was hit? Was it another vehicle that was hit? Did he hit a curb? We can't see that. There's no ID. We have 2 vehicles. We don't know which vehicle, and the officers testified they don't know what that vehicle is. It's an unknown vehicle. Never pursued who was driving it. But no, they were just looking at this particular vehicle. But then they went back and looked, see, there was another vehicle within less than a second. No eyewitnesses, Your Honor. At best. For those reasons, Your Honor, I don't think there's enough evidence to bind Mr. Rooker over on the reckless driving causing death. It just isn't there.
Let me see the video again of what you maintain is the defendant.
The residential video, correct?
Right.
Your Honor, may I respond?
Yes.
Your Honor, I believe the argument is gonna be some kind of causation. But in the video at 7 seconds, you clearly see a white vehicle strike the victim who states ow. You can see what appears to be a cell phone fly up in the air and fall down. And the individual is laying in the middle of the street. Now we have another vehicle that appears to be black come and then what appears to be a strike the victim again. However, that's a causation and that's foreseeability, whether that individual knew or not knew, that resolves the defendant of any kind of criminal action against him. So, Your Honor, it is clear from the video that the white Kia struck this individual. That's all.
All right, so my viewing of the video, the residential video shows a white vehicle coming down the street. And I think we sufficiently track this vehicle. That's the same vehicle that made the left turn onto the street, presumably going onto this street here. That vehicle, from my purview, is a vehicle who struck. It looks like a person. You can tell from the way the car goes up, the sounds that we hear afterwards. And then we have the defendant admitting that he was involved in an accident beforehand, shortly before this particular accident. So we don't have anyone else in the vehicle, but the defendant who maintains or tells us that he was the person that was in that vehicle. I do see after that vehicle strikes that person, something laying in the roadway appearing to be a body and then another car coming by. So if your argument is causation or identification, let's go with causation for now. If it is causation, that's not going to hold water either, because if not for the defendant hitting this person in the street, he wouldn't have been in a position to be vulnerable laying in the street for a second car to hit him. So I have no issue with causation. Identification, the defendant gives us that. Circumstantially speaking, by him saying that he was the driver of this particular vehicle, that vehicle was involved in an accident, we're able to track that same vehicle within seconds, if not a few minutes, a couple of minutes, get involved in another accident, hitting the pedestrian. I don't think there's an issue.
That being said, the court is satisfied that the burden of probable cause as it relates to the charges contained in the complaint form. The court finds those charges were committed with the city of Detroit. The court finds probable cause to believe this defendant committed. Defendant will be found local to Lane County Third Circuit Court Criminal Division for further proceedings. His arraignment on the information date and time will be July 25th, 2023, 9 o'clock a.m.
Thank you.
Mr. Walker.
Oh, sorry. I have your exhibits.
Have a good day, Your Honor.
Thank you. You too. Along with your exhibits. Thank you. You too.
Thank you.
No, that's it for today. We just hope to see you tomorrow, same bat station, same bat time. Have a good day.
I'll see you tomorrow, Judge.
All right, take care.
Hold on. Oh, do you have the chamber's number or anything like that? Or can you send that to me?
I'm sorry, do I have a what?
You have a chamber's number or email?
My email is kenneth.king@36thdistrictcourt.org.
Okay, thank you. Have a good day.
Thanks, you too.